That was rejected by my Lord Justice Kuria. Now her lordship is sitting in division bench. One of the accused has to go on surgery. So lordship may kindly constitute a bench to take up this matter, consisting my Lord Justice Thakuria.
It was rejected by?
By my Lord Justice Thakuria.
Okay.
Hello, let's tomorrow.
May it please your lordship, as regard item number 11, my lord, with the consent of other side, matter may kindly be taken up next week, my lord. Today I have next week, my lord. 11, my lord.
You are putting on behalf of?
Petition, in respondent, your lord.
And for the
My learned
appellant.
Okay. On request made by Mr.
A. Goyal.
A. Goyal, Learned Counsel for the respondents. Please come back after 1 week.
Lordship on 11th, next Monday, Lordship.
Next Monday will be difficult.
Next week, any day, my
20 Lordship.
No, 22nd.
Lordship.
26.
May I please, your lordship? My lord, I beg to mention regarding item number 13 and 14. My lord, may not be pleased to take up.
I would be.
Well,
13 and 14.
my lord, may I pray for a date, my
I
lord?
can give a date.
All right.
I have similar prayer. Item number 8 and 9.
Very good.
13 and 14.
My lord, my lord.
For item number 8 and 9, possibly lordship may not like to take up. Item 8 and 9.
This different, so I have the bench without one of us. Within brackets. Yes.
Only two this today.
Okay.
Only two today.
May I please?
Yes.
I beg to mention for listing one hearing matter, Lord, in which my lord, the honorable court fixed the matter for listing in top of the list, and after that, my lord, it was listed in the hearing list, but his hearing list is not taking up, my lord. So, my lord, next week, Tuesday, my lord,
Thursday,
At-
23rd.
23rd.
Lordship, item number 5 may be adjourned for 2 weeks, my. I have obtained the consent of the opposite party.
With Mr.
J. Lashkar, my.
For the petitioner.
For
the
appellant.
Appellant.
Well.
On request by Mr. J. Latkar, Learned Counsel for appellant. Please come to.
Apply.
My lord, with the consent of the other side, I beg to mention item 6.
Yes.
If it can come after, in the second week of December, lordship.
Okay, on request made by MS. B. Chowdhury.
Yes, lordship.
Learned Counsel for the appellant. Please come back on. When do you want? 13th? 13th of December?
12th of December, lordship.
There's a hearing day.
Yes, lordship.
12th.
Great.
Please, the lordships. Lordships, may I pray for listing of an interlocutory application for impleading of parties? Can it be on 17th?
Not 17th. Monday, 20.
Of next. May I please your lordship, also I beg to mention for listing lordship, matter relating to selection of LPG distributor lordship, matter is in hearing stage.
Okay. Twenty-eight. 28.
Item 1 of daily list motion.
Oh, I don't know.
May I please, my lord? My lord, this PL has been filed for regarding some wastage of government estate. So I'm just, prior to my submission, my lord, I just wanted to submit few lines about the background of this case. Initially, my lord, I have participated 4 packages of PMJSY works. And regarding some asking of some additional performance security, I have approached the Honorable High Court, and according to English single bench, it has been dismissed. After that, my lord, we have approached in division bench also. After that, it was also dismissed. After that, my lord, we have given some representation to adjust some security deposits which has been lying in the form of the security deposit of certain amounts of like forest royalty and etc., which can be adjusted from our in comparison to the additional performance security. My lord, it is very needful to say that this in the submission of the security, when we have submitted, there was an interim order, my lord, so regarding to not to take any coercive action till the returnable date of the next date. That was, my lord. I will come to later on. I will show you the exact order. On 28th of February, my lord, wherein the interim protection was there, the security deposit has been forfeited by the PWD authorities. That is on 28/2/2023, my lord. Why it was happened, my lord, I will come to the next point. Now, my lord, please come to page number 96 and pair number 2 for a moment. That is a letter of acceptance, my lord, of the bidder, that is Lily Enterprise. When I quoted my rates, my lord, that was in 17.86% below of the estimated value of contract, my lord. And you just go to the, my lord, in the second para of this LOA, where is the department has allotted the works in favor of this company, quoting 9.97% above the schedule of rates, my lord. That is the, now I'm coming to the next point, my lord, how the government money has been misutilized, how the government money is likely to be misutilized, my lord. For a moment, my lord, please come to page number 27, my lord.
That we have seen.
That is, now I am just
Are you not supposed to approach a single bench?
for regarding the PL, no, my lord. That is
How can this be treated as a PI?
I am just coming to that point, my lord. Please come to page number 110, my lord, for a moment.
Yeah, I agree with page 96, isn't it?
Page 96,
LOA.
LOA. Yeah,
Yeah,
that
I
is
agree with
about.
that.
I'm not for the works, my lord. I'm just showing the one very simple line. Is please come to page number 110, my lord, for a moment, and pair number 21. Of the right side of the reply. Pair number 21, my lord.
110.
Pair number 21, 110 number page, my lord. May I read, my lord?
Yes.
The work was allotted to Messrs. Lily Enterprise at 9.9% above the estimated cost, which is met up from the savings of the other allotted works of the same bench. My question is that, my lord, where is that above rate which can be adjusted as per the chief engineer has given the reply to the Prime Minister's grievance cell, my lord? Where is the 9.97% above? That is near about 5 crore 21 lakh something, my lord. It is not the government exchequer money, my lord. It is a government exchequer money, my lord. And where is my rate, my lord? In spite of the where is the single bench has given the opportunity to look into the matter. I'm just coming to the page number 75 for a moment, my lord. I'm just reading the relevant portion from the bottom of the page, my lord. May I read, my lord?
relevant portion.
A relevant portion. As an exceptional case, direct the authorities in question, namely the chief engineer, public works department, border roads, to reconsider the offer made by the petitioner regarding his willingness to pay the entire amount of additional performance security only for the work in question, namely package number so and so, my lord. The learned counsel for the petitioner has also considered that the offer made is only in respect of the said work, and for the other 3 works, he is not in a position to make such offer. Initially, my lord, we have been allotted 4 works. Later on, we have come to the court for regarding to at least give the 1 work for which I wanted to deposit the additional performance security. They did not agree. After the, in spite of the court, court saying they did not agree, because my lord, I will not read the particular para, if my lordship. I am just going to a very vital point, my lord.
This was complied with by the speaking order. Yes.
Yeah, this is complied with the speaking order, but in the speaking order, my lord, they have, if you come to them, I will just show you the speaking order, my lord.
Page 78. 78.
78, my lord. You just, my lord, please come to the para number 2 of the speaking order, page number 77.
Yes.
On failure of the bidder to submit PS and additional performance, the bidder's bid security was forfeited on 28/2/2023 as per the provision of clause number 30 of the instruction of the bidders, my lord. On 28/2/2020, they have forfeited my EMD. And the my lord, come to the page number 61 for amendment. 61, my lord. Sorry, my lord, page number 65. I'm just telling you the relevant portion, my lord. Balancing that from the bottom to 3rd para, my lord. Balancing the equities, it is directed that till the next day, that is fixed on 30/3/2023, my lord, no coercive action of any measure connected with the additional performance security to be taken against the petitioner. But they have forfeited on the EMD on 28/2/2023, my lord. Now, it is very important to say, my lord, I'm just saying one line of the very important, why these PWT authorities extending from time to time and issued numerous corrigendum, my lord, to till that their blue-eyed persons can be qualified in this particular project, my lord. I'm telling you that, for example, my lord, please come to prayer number
before the single bench, not before us,
my lord.
not by way of PL.
In fact, my lord, this speaking order is under challenge, my lord, in page 79. Yes, so it's pending, my lord. This issue is pending before a single judge.
So that is pending.
Litigation after
So you have
litigation,
to
he has been
single
filing for the same cause.
No, my lord.
In
Actually,
fact, I pray, my lord, this PI should be dismissed with cost. This is a private litigation, not a private.
no, my lord. I am just telling you the why this my petition is very simple, my lord. I am not begging about the works, my lord. Neither I am asking for the any stay order. I am just telling you about the how the government money has been misused, my
We
lord.
can't accept this. We can't accept.
See, it's a commercial transaction, Lordship, between the
Yes.
parties and PW department. Lordship may dismiss this PI, Lordship, with an exemplary cost, Lordship, wastage of court's valuable time, Lordship. This kind of petition is not encouraged by this honorable court, Lordship. Lordship may dismiss this petition with a Lordship exemplary cost, Lordship.
Yes.
Lordship may impose the cost,
You have
otherwise,
issued-
Lordship,
you have
they will
already
oppose again and again.
challenged the order before the single bench. Now you are coming by way of this PIL.
No, that was a separate cause of action, my lord.
I'll
Earlier.
give you an option. We are dismissing this PIL with cost, or you can withdraw this PIL. It's up to you.
Wastage of court's valuable time, Lordship.
Lordship is saying, when you have challenged that 10/4/23 order before the honorable,
My lord.
that foreclosed your everything. That you have been, you cannot participate in further tenders.
My
So
lord.
it's closed.
My
So
lord.
that is under challenge.
My lord.
And the honorable court has said anything action pursuant to this would be subject to the outcome of the case.
My lord.
Now, all these things are subject to outcome. all these things, what have happened is a consequence of that.
But my lord, the
Whatever
work has already been allotted.
Fine,
My-
fine.
my
But
lord.
that your right, if any, would be considered by the Honorable Singleton. This PIL, my lord, is trying to indicate that is not maintained. Because if there is any grievance, it would be before the Honorable Singleton. You'll have to challenge that.
It has already been
It's not
challenged,
a
my lord.
question, it's not a question that you cannot challenge that before the Honorable Singleton. PIL would come in wherein a large section of people are not in a position to come to the
But
court. An issue is taken up.
But my lord, I am just looking about how the work has been allotted in a very high exorbitant rate.
Fine, that you can always take it up before the Honorable Single Judge, because that would be a ground of challenge. Why this repetition? That's why my lord is saying that you either withdraw it or we have to interfere, then we'll have to give reasons. That might cause you trouble there also.
Okay, then liberty has been given to do this petition, my lord.
No liberty. Petition in person, procedural of this.
High level, my lord.
Two.
Meet with your lordship. In this case, lordship, I have challenged the appointment of the private respondents, lordship,
Bench three matter. Huh?
against the advertisement, lordship, that is on page.
Perhaps this is a bench three matter, subject to correction, my lord. Perhaps it's a bench three matter. I don't know how this matter has come up before the DB.
Lordship. As informed, lordship, if we made Guwahati High Court a party, lordship, the matter goes to
No,
division.
not
bench,
in all
lordship.
matters. There was a notification.
So
but-
filing section asked us to make division bench matter, lordship.
But not all matters, my lord.
There is a notification.
Yes,
You have a copy of the notification?
Mr. Das.
yes,
Yes.
yes. No, this notification is 14 August 2023. It says that in supersession of previous orders and notifications in this regard, the Honorable Chief Justice has been pleased to direct that except service matters pertaining to staff of Guwahati High Court and subordinate courts, all of the cases pertaining to the principal seat of the High Court and in its permanent benches in which Guwahati High Court is arraigned as party shall henceforth be listed before the division bench one in the principal seat at Guwahati. So this is
Family. court.
except service matters pertaining to staff of Guwahati High Court and subordinate courts.
Family court. Family court. Subordinate civil bench is this one, filing of corporate cases.
Except service matters. These are service matters.
Lordship, we earlier filed a single bench matter, lordship. Thereafter, the filing section asked us to rectify it and to make it a DB matter, lordship. Thereafter, as per their instruction, lordship, we have in. They said there is an notification, lordship.
Except service matters.
Except service matters.
Family court matter, lordship. Appointment of peon in family court, lordship.
It's some
It's a
under subordinate court.
lordship.
There may be
This is for the concern roasting bench.
Single bench, lordship, bench three matter, lordship.
bench three matter.
We got the
Obliged.
bench.
Obliged.
Highly obliged.
Three.
Lordship, the petition challenges an auction notice by a secured creditor, which is the respondent Union Bank. And the basic ground of challenge is that that is the petitioners, Assam T Employees Provident Fund Organization, we are, so to speak, the custodians of statutory dues. And this statutory due, this is our basic submission, that this statutory due trumps and overrides the rights of a secured creditor to its own security interests. That is the basic submission. Lordship, who am I and what is it we're trying to protect? Lordship may take a look at the act.
Yes.
Because this is the act that gives us the first charge. Lordship, just a few provisions I'll go through just to explain who am I and what am I trying to protect. 2A, contribution. Lordship may already be aware. 2A is page 2. Lordship has 2A of page 2.
Yes.
Yes. So it defines contribution. And what is the contribution? It's deduction from wages of an employee for deposit to the provident fund or insurance fund and amounts payable by the employee in respect of each employee to the provident fund and insurance fund. So it's deduction from wages to provident fund, insurance funds, and equivalent amount by the employer to the provident fund. Lordship then is 3.3. Next page, page 4. 3.3, Lordship. The contribution, which I just read the definition, which shall be paid by the employer to the provident fund, shall be 12% of the total wages, including such allowances, etc. And the employer's contribution shall also be equal. So there are two components of the contribution. Deduction from my salary at 12% and equal amount of 12% equivalent the employer has to put in. So this is what the fund is, which I'm trying to protect. Lordship, now, how sacrosanct is it? Page 6, section 6. Lordship has section 6.
Yes.
Protection against attachment. The amounts standing to the credit of any member in the provident fund, pension fund, insurance fund shall not in any way be capable of being assigned or charged and shall not be liable to attachment under any decree or order of any court in respect of any debt liability incurred by the members, neither official assignee nor any receiver appointed under the Provincial Insolvency Act shall be entitled to or have any claim on such amounts. So this fund, which is basically deduction of salaries, I've already earned the salary, a part of it is cut and put it in. It is so sacrosanct that nobody can touch it. That's section 6. Now, Lordship, the first charge is page 8, which is the most relevant. Page 8, section 10. It reads priority of payment of contribution over debt. Lordship, the first subclause talks about priority. What we are concerned with subclause 2 at page 9. Lordship has it?
Yes.
It says, it begins, without prejudice to the provisions of subsection 1, if any amount is due from an employer, whether in respect of employees' contribution deducted from wages of the employees or employer's contribution for a period of more than 1 month, the amount so shall be deemed to be the first charge on the assets of the establishment and, Lordship, important, shall, notwithstanding anything contained in any other law for the time being in force, be paid in priority to all other debts. This is the first charge. Lordship, they have issued an auction notice enforcing their rights under SARFACI, section 13, without intervention of the court, section 13.7, enforcing their security interest. My submission is that by virtue of 10.2, this trumps, we've already enforced, Your Lordship. We've already issued a notice of attachment in November 19, and there's a receiver appointment. So my submission is that by virtue of 10.2, my first charge overrides their security interests. And fortunately for me, Lordship, the Supreme Court has already decided this issue. May I go through? Lordship, 2009 4 SCC, page 94. It's a 3-judge bench. Lordship, I'll read page 2 first. At page 105.
Page
2. Sorry, paragraph 2 at page 105.
Yes.
First paragraph. Lordship, may I read? Whether section 38C of Bombay Sales Tax Act or section 26B of Kerala Sales Tax Act, these are the state acts, and similar provisions, Lordship, it's not limited to only those two, and similar provisions contained in any other state legislation by which first charge has been created on the property of the dealer or such person who is liable to pay sales tax, etc., are inconsistent with the provision contained in DRT Act and SARFAESI Act, for short, for enforcement of security interests, and whether by virtue of the non-obstantive clauses contained in 34 of DRT and 35 of Securitization Act, two central legislations will have primacy over state legislations are questions which raise for determination. This is squarely before it. Lordship, the sections you'll find at page 127, paragraph 95. The Bombay sales tax is there, Lordship. The Kerala sales tax is there. Lordship, what I will read is the Employees Provident Fund Act, because this is exactly pari materia to what I just read out from the Assam Act. That is at page 129. Lordship has 96.2 paragraph. That's the Employees Provident Fund and Miscellaneous Provisions Act. It's a central act. And it's subclause 2. Lordship has subclause 2 at page 129. This is the Employees Provident Fund. It's pari materia with what I just read out. Lordship will realize it in a minute. Lordship has paragraph. Yes. Without prejudice to the provisions of subsection 1, if any amount is due from any employer, whether in respect of employee's contribution deducted from the wages of the employee or employer's contribution, the amount so due shall be deemed to be the first charge on the assets of the establishment and shall, notwithstanding anything contained in any other law for the time being in force, be paid in priority to all other debts. So the issue was whether this trumps or SARFAESI trumps. And they relied on the non-abstantive or SARFAESI. What is the finding, Your Lordship? Page 135, paragraph 116. Lordship analyzes all of the section, 529 of Companies Act, etc. I will not take, at this instance, I won't. Paragraph 116, Your Lordship, at page 135. Lordship has it? The non-obstantive clauses, because they rely on these non-obstantive clauses. Non-obstantive clauses of DRT and 35 of Securitization Act give overriding effect to the provision of those acts only if there is anything inconsistent contained in any other law or instrument having effect by virtue of another. In other words, if there is no provision in the other enactment which are inconsistent with DRT or Securitization Act, the provision contained in those acts meaning DRT and SARFAESI, cannot override other legislations. Section 38 of Bombay Act, Section 26 of Kerala Act also contain non-obstantive clauses and give statutory recognition to priority of state charge over the other assets, which have been recognized by Indian High Courts even before 1950. Lordship, I showed you, enactment it's sacrosanct, it's somebody else's property, it's not property of the estate, which is why it's kept out. In other words, these sections and similar section contained and similar provisions contained in other state legislations not only create a first charge on the property of the dealer or any person liable to pay the sales tax, etc., but also give them overriding effect over other laws. They re-emphasize this at page 140, paragraph 128. It begins from 128, Lordship, 126, where they say the intention was, considering even these acts, the state acts were prior to DRT and SARFAESI Act. So 126 says that if the parliament wanted to make it overriding, then they would have, they have not. And then they repeat this finding, Lordship, at page, paragraph 128, 141 page. Lordship has page 141, paragraph 128. 128 paragraph. If the provisions of the DRT Act and the Securitization Act are interpreted, keeping in view the background, the context in which these legislations were enacted, and purpose sought to be achieved by their enactment, it becomes clear that the two legislations are intended to create a new dispensation for expeditious recovery of dues of banks, financial institutions, and secured creditors, and adjudication of their grievances made by any aggrieved person qua procedures adopted by the bank, financial institutions, and other creditors. But the provision contained therein cannot be read as creating a first charge in favor of banks, etc. So the 116 was the finding that that's the first charge. 128 is that surfacey and DRT does not create. And Lordship, in fact, paragraph, if you just go in front, last line of paragraph 126, this is the reason. In the same page, Lordship. The reason for this omission appears to be that the new legal regime envisages transfer of secured asset to private companies. So what basically the Honorable Court is trying to say is that some funds are sacrosanct. They don't belong to the state funds. The state therefore has a first charge. And secured creditors eventually will go to private individuals. So between private secured creditors and state, the state will have a overriding effect. Lordship, paragraph 129. I'll just read 3 paragraphs to complete. May I, Your Lordship? Paragraph 129. If the Parliament intended to give priority to dues to banks, financial institutions, and other secured creditors over first charge created under state legislation, and then they say workmen, estate, etc., etc. Last line, Your Lordship. Would have been incorporated in the DRT and the Securitization Act. This reiterates that there is no first charge in DRT and RFAC. 130. Undisputably, the 2 enactments do not contain similar provisions to Workmen Compensation Act, etc. In absence of any specific provision to that effect, it is not possible to read any conflict or inconsistency or overlapping between the provisions of DRT and Securitization Act on one hand, and the Bombay Act and Kerala Act on the other hand, and the non-obstantive clauses of DRT and Securitization Act cannot be invoked for declaring that the first charge created under the state legislation will not operate qua or affect the proceeding initiated by the banks, financial institutions, other secured creditors for recovery of their dues or enforcement of the securities as the case may be. Lordship, and Lordship, just to illustrate what happened in one of there was a batch matter, Lordship. Page 161. Lordship, page 160, sorry. Page 160, see. The facts will clearly tell you exactly how it trumps. I will just read the first case. It was a batch matter. So I'm only going to read the facts of Civil Appeal 95 of 2005, paragraph 177. Your Lordship has it?
Yes.
Page 160. It's page 160 and paragraph 177. Your Lordship. So this is facts, how it operates. The facts of the case have been set out earlier part. Recapitulation. Suit was filed by the bank for recovery of its due and was transferred to the tribunal. Before that, before the suit filed, before that, Tehsildar attached the property on so-and-so for areas of Sales Act. Exactly how we did it. We attached the properties under our own Assam Act. The bank challenged the notice issued to the Tehsil for recovering of the areas of sales tax, but could not persuade the single judge, who held, in view of the Kerala Act, dues of the state will have priority. The order of the single judge was approved by the division bench. In our opinion, the view taken by Kerala High Court is in consonance with what we have held in the earlier part of the judgment regarding primacy of state's first charge over the debts of banks, financial institutions, and secured creditors. Therefore, the impugned order does not call for interference. So, Lordship, this is our submission. We have enforced, Lordship may see, we have enforced our right of first charge by way of notice on 15th of November 19. Lordship, page 56. Last recall, order to recall. First, we gave notice, Your Lordship, at page 53. Notice of attachment, page 53. Followed by page 56, order of attachment. And page 57 is the enforcement officer saying it has been attached. And we've appointed a receiver, page 69, Your Lordship.
Yes.
It is the fund control officer who's the receiver. Now, Lordship, there's another problem with, we actually reached out to the bank to say that we have already exercised our rights. They've not replied. And the other problem with the auction notice is that the dues, they did not consult us. And the dues that is reflected as our dues is actually inaccurate. In this petition, our due is, Your Lordship, 83 lakhs plus interest. And this is due is what? This is workers' wages deducted in Provident Fund and employees' contribution and insurance and deposit link insurance. So these are all statutory dues owing to the workers, which we hold in trust. So they have reflected that as 56. So even on the face of it, that auction notice on figures is wrong. Besides, it does not having jurisdiction. Lordship, there's one more case. If your Lordship is not convinced, there's one more case where similarly in 2011, there was.
Your Lordship 26E of the SURFACE Act. And Your Lordship, we are not denying their liability, and we have already shown in our sale notice also. It is at page number 40. Your Lordship may kindly first come to 26E of the SURFACE Act. E. Your Lordship, this is an amendment in the year of 2016. So the judgment of 2005 and the judgment of 2011 is not applicable in this case. May I read, Your Lordship, that notwithstanding anything contained in any other law for the time being in force after the registration of the security interest, the debt due to the secured creditor shall be paid in priority over all other debts and all revenues, taxes, cess, and other rate payable to the central government, state government, or the local authorities. And Your Lordship may kindly come to page number 40 of their writ petition. It is very small, Your Lordship, but in the column side, in the last column, that is 1, 2, 3, 4, 5, 6 number column, we have shown their dues in the encumbrance point.
Page 40 is something else. You are taking up.
Oh, sorry, Your Lordship, 90. Because in this, the photo state, it's shown like in 40.
So we have a
This is the sale notice. It is in very small words. In the last column,
we have a better copy. Good idea. Lordship, we've got better copies. It was filed. We didn't have that much time. Now we have. So it's page 90.
It is
better copy
page
of
number
page
90 and exam number 16. We have shown their encumbrance. Now, Your Lordship may kindly come to Rule 9(7) of the Secretary's Enforcement Rules, Your Lordship. Rule 9(7), Your Lordship. Yes, 9(7). Your Lordship, the first thing we have shown their encumbrance on the liability side, that whoever will purchase, he has to pay their liabilities first. Now, Your Lordship, where the immovable property sold is subject to any encumbrance, the authorized officer may, if the things fit, allow the purchaser to deposit with him the money required to discharge the encumbrance and any interest due thereon, together with such additional amount that may be sufficient to meet the contingencies or further cost, expenses, and interest as may be determined by him. And Rule 9(8), on such deposit of the money for discharge of the encumbrance, the authorized officer issue and cause the purchaser to issue notices to the person interested or entitled to the money deposited with him and take step for making payment. Your Lordship, from which point they are prejudiced?
One thing, they have made a attention now that you have shown 56 odd crores, but according to them, their notice says 36. But now she has come up and they.
Yes, Your Lordship, whatever be their liability, we have to pay.
This money has to come to you, it has to come to them. But who will have the first charge and how they proceed? Because say 9(7), we say that that is permissible. You can proceed and then you will pay
Yes.
But if it's their actual dues are not reflected.
Yes, your lordship, it is 56 lakhs.
But she is now contending that it is around 89 for.
Yes, your lordship, but along with interest and cost also.
Because see, that amount is a public interest, it's for the tea garden employees.
Yes, your lordship.
That has to be given some, you may proceed. but
Yes.
That amount has to be taken in.
Yes, yes, yes. Their amount will be taken care of, your lordship. There is nothing.
This notice does not.
Your lordship, it is shown as 56 lakh along with interest. So
Yes,
whatever be their interest and cost, we have to pay.
Lordship, Me- Lordship, I have an answer to 26E.
Union. Let's start David, then let's see. Appears for the response number 1. You are appearing for?
For respondent number, your lordship, Union Bank of India.
2 and 3.
Yes, your lordship.
Two and the? You're good.
M. Sharma.
M. Sharma, then counsel. Appears for the Union Bank of India, of the respondents. 2 and 3.
Yes, sir.
You'll have to take steps. The petitioner to take steps for service of notice on respondents. 4, 5, 6 and 7. By respondents are notified. This after 4 weeks. 4 weeks. In the interim. Where's the position notice?
It's in.
Your lordship, it is the sale notice. That is tomorrow the sale is due.
86 is the possession notice, your lordship, and auction notice is page 90. We've impugned both. 86 and 90.
The position notice dated 22/8/2023 issued by the Union Bank of India by the authorized officer, Union Bank of India, and
90.
e-action and the e-auction notice, e-auction sale notice dated
1310.
13/10.
2023, published on 1510.
15/10/2020.
Which was published on 15/10/2023. Shall remain suspended.
Obliged, your lordship. Lordship, item 23 is impugning the same regarding a different tea estate. I'm praying same auction notice.
Same auction?
Same auction notice, 1310. Item
Your lordship,
23.
Only one small submission.
1 minute.
That is, your lordship, we may be allowed to continue with the auction, your lordship. Because our amount is much higher than that.
No.
Dues is there.
Wait for it.
Yeah. 23 says again.
Possession notice in the second case.
Lordship, it's page 34, 35 is the auction notice.
No, position notice.
No possession. Lordship, we've said in para 5, but we've not given the document. Para 5, we aver symbolic possession.
Not under challenge, your lordship, even. In the prayer portion, only e-auction notice has been checked.
Item number 23. There was stay only the e-auction notice.
Yes, your lordship.
The second case, yeah, e-auction notice. First case, they are paid for 2.
Possession.
Obliged, your
But
lordship.
you will have to take into account the 2016 amendment.
Lordship, I have an answer. The other case, actually, there's a 2011 case which deals with
Your lordship,
529
new
of
judgment
Companies
is
Act.
also there. That is 2023.
The second case is item number?
23.
23, your lordship.
Item 23. Item 23. Question is? Obliged, your lordship.
I noted it.
Four of daily list admission.
May I please your lordship, in this case, I am paying for 2 weeks time to file affidavit marriage.
Lordship, your notice was issued on 19/7, but the respondents are yet to file their affidavits, Lordship.
Affidavit in opposition.
Madam.
Yes, none of the
You have been
respondents have
given so
filed,
many
Lordship.
times. 29/8/2023, 9/10,
Madam.
2023.
I will file marriage within 2 weeks, madam.
Okay.
None of the
MS
respondents has filed,
LW
Lordship.
MSS. Yeah.
Yes, okay, madam.
Understanding also?
No, I am appearing on behalf of P. Nayak, madam. He is just selling also for GMC,
Appearing
madam.
on behalf of the Nayak, understanding also GMC is allowed. How much time?
2 weeks, madam.
2 weeks time. Well, okay. This not to be this.
Nice.
Seven.
May it please your lordship. My lord, appellant before your lordship is serving as assistant professor and head of the Department of Computer Science and Application in Karimganj College. Now, he got his MPhil degree in the year 2008. My lord, these are the important dates. And the PhD on 2/5/2012. Now, in both the occasions, my lord, the appellant was pursuing research course simultaneously with teaching assignment. Under that circumstances, my lord, the teaching experience, the marks, they will get it. Now, recently, my lord, the other side may say is covered by one decision where Justice Unikrishnan was also there on behalf of respondent number 1. They may say it is covered, but it's not covered in the sense, my lord. I'll first deal with that judgment first.
That was pertaining to JR.
Yes, exactly, my lord. The difference is, my lord, there they are required to do service. I mean, the teaching assignment for 10 hours in a week. But ours is a case, it is not that. If he is a full-fledged assistant professor and he is doing more than 40 hours assignment in a week. So therefore, this judgment is not going to, my lord, your lordship may see the particular paragraphs where I'll take your lordships. Your lordship may come to page 8, my lord, paragraph.
Of the writ appeal,
No, my lord, this is a judgment which I am referring.
writ appeal, 367.
3 is right. Now, your lordship, the relevant paragraph, page 18, the next page, your lordship kindly see. By referring to the aforesaid condition number 3, Mr. Swansu submitted that for counting the teaching experience, it was essential that the candidate concerned must have imparted actual total hours of teaching in the particular year with the standard of teaching hours of a regular assistant professor as per UGC guidelines. He submitted that to qualify the requirement of standard of teaching hours, the person concerned, this is important, my lord, must impart teaching for 40 hours a week as provided by clause 15.1 of the UGC regulation 2010. So my case is governed by this. Now, Mr. So-and-so referred to the University Grants Commission, minimum qualifications for appointment of teachers and other academic staff in universities and colleges, and other measures for the maintenance of standards in higher education, regulation so-and-so, and more particularly the clause 3.9.1. Now, these are the thing, my lord, where if they impart education without taking leave, I mean, after taking leave, then the experience, teaching experience will not be counted. This is 3.9.0. Our case is not governed by these. Now, then paragraph 20, my lord. Mr. So-and-so further submitted that the writ appellant got inducted into the Junior Research Fellowship Scheme. Now, Junior Research Fellowship is a scheme where they are the student, my lord. They are not a full-fledged employee. So here in this particular writ appeal, he was a junior research fellow being offered by the UGC in the year 2013, and thus it does not lie in her mouth to say that the UGC guideline, this is a different thing. Now, this is the case about, my lord. I am not saying much about this. Now, let us come back to our case, my lord. Now, pursuant to the advertisement dated 8/5/2017, which your lordship will get at page 59, The applicant applied for the post of Assistant Professor Computer Science. Now, the selection committee, what happened, my lord, there are two colleges where I have applied. That is Dalgaon, Tulungia, and Amjanga. These are the two colleges I have applied for. Now, the selection committee of Dalgaon, that college awarded no marks for MPhil degree, where I am entitled to get 5 marks on that. And in place of getting marks in the teaching experience, they have allowed 2 marks where I am entitled to get 5 marks, because your lordship will find I have got my MPhil in the year 2008. The advertisement is in the year 2017. Now, supposing whether I prosecute my studies without leave or with leave, my lord, this is immaterial, because 2008 to 2017, your lordship will find that the 9 years of teaching experience. Now, maximum I can get 5 marks. Now, your lordship will find in the 2 of the colleges, they have given 5 marks in MPhil and the 5 marks in teaching experience. The same subject teacher, my lord, in Dalgaon, they have given no marks on MPhil and 2 marks in, my lord, teaching experience. Now, the learned single judge remanded the matter to the Director of Higher Education to consider it, but saying that I will not get that marks. Now, my lord, it's a case where operation is successful, patient died. It's almost like that. Now, my lord, I'll take your lordship to the finding.
So just one second.
Doctor, if you can take us to that paragraph 6 on 173.
Page 170, the chart is there. Your lordship may look at. My lord, page 174. MPhil, your lordship kindly see. Marks, maximum marks is 5. I have been given 5. Then teaching experience 5. Is for MPhil, my lord. 5 marks, highest marks, I have got it. Then teaching, my lord, so for Dalgaon is concerned, they have given 2. And the MPhil, they have given 0. But the same subject teacher, he has given me in other colleges 5 marks, 5 marks.
Para 7, page 17.
Beg your pardon, ma'am.
Para 7. Para 7 of the assessment.
Yes, yes.
Page
Para,
174.
17.
yes. Para 7, page 174. To project entitlement of the petitioner to 5 marks for teaching experience, it is submitted that although under OM number so-and-so, it is so-and-so, it was provided that the period of time taken to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the position, but white communication under so-and-so, so-and-so, dated 1/3/2016, the Secretary UGC had clarified that the period of active service spent on pursuing research degree, that is for acquiring PhD degree simultaneously without taking any kind of leave, may be counted as teaching experience for the purpose of direct recruitment, promotion to the post of assistant professor and above. Accordingly, it is submitted that the MPhil degree being research-based, the same principle would apply there also. Par contra, the Learned Standing Council for the Higher Education Department has countered the communication of the Secretary so-and-so, so-and-so by submitting that as per clause 3.9.0 of the University Grants Commission on minimum qualifications for appointment of teachers and other academic staff in universities and colleges, and measures for the maintenance of standards in higher education, published in the official gazette with UGC notification dated so-and-so, it is observed that the period of time taken by candidates to acquire MPhil and or PhD degrees shall not be considered in teaching research experience to be claimed for appointment in teaching positions. Now, my lord, I am clarifying this position.
Go further.
My lord. In the office memorandum dated so-and-so, it has been mentioned in clause thereto that the period of time taken by candidates to acquire MPhil and PhD degrees shall not be considered for teaching research experience. to be claimed for appointment to the position clause so and so, so and so. The Learned Standing Council for the Higher Education Department has demonstrated that the reference regarding so and so as mentioned in so and so of the said OM dated 25/6/2012 is preferable to UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges, and measures for the maintenance of standards in higher education, bearing number so and so, so and so. The period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching positions. The said clause is continued in the subsequently notified University Grants Commission on minimum qualifications for appointment of teachers and other academic staff in universities and colleges, and measures for the maintenance of standards in higher education, bearing number so and so dated so and so. Resultantly, the petitioner is not found entitled to the benefit of DO letter dated so and so referred to herein before, because the said clarification is followed by the herein before referred UGC notification dated 4/5/2016. Thus, the point of determination number A is answered by holding that the respondent number 2 had not committed any illegality in refusing to consider marks to the petitioner by treating time spent for pursuing MPhil and or PhD degree as teaching experience, notwithstanding that the petitioner might have actually rendered service to his college during that time. Now, your lordship, kindly see at page 196. And at page 98, your lordship, kindly see 3.11, page 198. Clause 3.11. The time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching positions. Further, the period of active service, your lordship, kindly mark this line. Further, the period of active service spent on pursuing research degree simultaneously with teaching assignment without taking any kind of leave shall be counted as teaching experience for the purpose of direct recruitment, promotion, regular faculty members up to 20%. Now, this is the clause, my lord, has not been given any credence. And my lord, apart from that, I am not asking for any mark on PhD. But learned single judge dealt it that as if I have asked for that. The lordship will find the column. There is no marks on PhD degree, and I did not ask for that also. Only MPhil I am required to be given. Apart from, my lord, your lordship, kindly see, if this clause is also not given credence. Now, what has happened? I have got my MPhil degree in the year 2008.
Let us retake it.
Yes. The time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching positions. Now, if I take leave, in that case, I am not getting any mark because I am not, my lord, having any experience, because teaching assignment I am not doing. But then, further, the period of active service spent on pursuing research degree simultaneously with teaching assignment without taking any kind of leave shall be counted as teaching experience for the purpose of direct recruitment, promotion, etc., etc. Now, assuming, my lord, even this clause is also not there. Now, MPhil I have obtained in the year 2008. The advertisement was given on 2017. Now, I have experience of 9 years. Now, the maximum marks I can get 5. So, I am eligible that 5 marks. Now, that was also not given. And other case, my lord, your lordship, kindly see other 2 colleges. The same subject teacher, they have given 5 marks on MPhil, 5 marks on teaching experience. Now, when coming in Dolgaon College, my lord, they did not give any marks on MPhil and 2 marks on teaching experience. Now, on those circumstances, my lord, there is, my lord, my lord, they did not argue on that. And the court also did not go into all that thing. Ultimately, what is happening? My lord, I am suffering for all these illegalities. Now, we are sending it back to the DHS. What he will do? Because the court has already said that I am satisfied that he is not entitled to get the marks. Now, what sort of thing he can adjudicate? My lord, what I say, the lordship may hear the entire matter in one go, my lord, because I'm losing my time because a person ultimately, my lord, his bar will be there. So therefore, already we have spent so too much of times before this honorable court. Therefore, can your lordship fix the date and hear the entire matter?
Yes, Google.
During hearing of entire matter, we have no objection. Once we fix the date for hearing, final hearing, we have no objection.
When do you
Otherwise, lordship, that
Any date as early as possible.
as per the agency regulations and findings of the honorable division bench, lord, it is very clear, lordship.
My lord, with all respect, I will say,
Can you have it tomorrow?
my lord, division bench judgment your lordship has said. This is a different world of difference. My lord, I will take your lordship to a judgment of the honorable appeals court. My lord, let us be fair. तुम्ही पैसा जितने मैं कहो दिया.
How about tomorrow?
Tomorrow, my lord.
Tomorrow we have any other case?
Call it me.
Okay. It's a matter for admission, area. Tomorrow's on 16th.
Lordship,
Oh, that, so Doctor, that 2018 notification of issues,
My lord.
that you will have to show how it is applicable. At least
Beg your
how
pardon.
it is applicable to the present selection.
Advertisement is 2017.
Yes. My lord, I'm conscious of that situation. Apart from that, if your lordship do not give any credence to that also, saying that the advertisement was of 2017, even in that case, my lord, in MPhil, I'm entitled to get 5 marks. Yes.
even lordship, that clarification which was 2016, it is lordship prior to the PGC notification 2016. Lord, will satisfy.
Much obliged.
Then
Check, I'm preferring this appeal being agreed by the judgment and order of the Honorable Single Judge, Your Lordship, dated 28/4/23, Your Lordship. That the judgment starts at page 90, Your Lordship, and the relevant portion by which the petition was dismissed, Your Lordship.
Notice issue.
It has been admitted, Your Lordship. This is admission.
This has not been admitted.
Lordship, Honorable Single Judge has rightly rejected, Lordship. Petitioner, appellant is the illegal irregular petitioner, Lordship. Already.
What, Mr.
Sharma.
Sharma, let me call. Appellant. Admit. Call for the reports. This is the matter for the vision post.
Very short date may be given, Lordship. I have already retired
After 2
and
weeks.
I am suffering from extreme penury, Your Lordship.
After 2 weeks.
The date may be fixed, Your Lordship.
Fifth December.
Obliged.
12.
My lord, the matter relates to
age of retirement of Ayurvedic doctors. Now, my lord, the learned single judge, relying on a recent decision of the Honorable Supreme Court in P.A. Bhatt's case, my lord, also relying on another decision of our High Court, my lord, rejected our claim. But learned single judge, my lord, miserably failed to notice the judgment in Naresh Kumar. Yes, no? My lord, on this issue, there are several decisions of the Supreme Court, my lord. If the Lordship will kindly have this compilation, the first decision, NDMC versus Dr. Ram Naresh Sharma. My lord will kindly come to page 1, or Lordship may straightway come to page 6. My lord, in this case, New Delhi Municipal Corporation, my lord, was before the Supreme Court. Please come to para 23. The common contention of the appellant before us is that classification of Ayush doctors and doctors under Central Health Service in different categories is reasonable and permissible in law. So this was the contention. This, however, does not appeal to us, and we are inclined to agree with the findings of the tribunal and Delhi High Court that classification is discriminatory and unreasonable, since doctors under both segments are performing the same function of treating and healing their patients. The only difference is that Ayush doctors, which include Ayurvedic, are using indigenous system of medicine like Ayurveda, Unani, etc. And CHS, that is Central Health Service doctors, are using allopathy for tending to their patients. In our understanding, the mode of treatment by itself under prevalent scheme of things does not qualify as an intelligible differentiation. Therefore, such unreasonable classification and discrimination based on it would be surely inconsistent with the Article 14 of the Constitution. The order of the Ayush Ministry dated 24/11/17, extending the age of superannuation to 65 years, also endorses such a view. This extension is in tune with the notification of Ministry of Health and Family Welfare dated 31/5/16. My lord, by 31/5/16 notification of the Government of India Ministry of Health, the age of superannuation of allopathic doctor was raised to 65. Subsequently, by this 24/11/17, my lord, the age of superannuation of Ayurvedic doctors were raised to 65 years. So based on that, my lord, we laid our claim before the authority. Authority did not respond. Then we approached the learned single judge. Then learned single judge also did not. Therefore, we were approaching your lordships. Now, para 24. The doctors under Ayush and CHS render service to patient, and on this core aspect, there is nothing to distinguish them. Therefore, no rational justification is seen for having different days for restoring the benefit of extended age of superannuation to these two categories of doctors. Hence, Ayush Ministry dated so-and-so must be retrospectively applied from 31/5/16 to all concerned, the respondent doctors in the present appeal. All consequences must follow from this conclusion. My lord, learned single judge, though my lord referred to this, my lord, but did not rely upon this, my lord, and instead, in a subsequent judgment, the learned single judge relied upon and this rejected our claim. So therefore, my humble submission is, my lord, and the case which the learned single judge relied, my lord, those are regarding pay parity. This is a case of age of superannuation. Now, my lord will kindly come to this second judgment, my lord. This is again by Telangana High Court, which has been upheld by Supreme Court. Page 7 to 14. Please come to page 13, my lord. This is the division bench judgment of the Telangana High Court. Thus, in Ramnaresh Sharma, stand taken by the municipal corporation was that Ayush doctors were not at par with doctors practicing modern medicine. Therefore, classification of Ayush doctors and doctors under Central Health Service as separate categories was justified by the central government. Supreme Court did not agree with such classification and held such classification to be discriminatory and unreasonable. It was held that doctors under both segments are performing the same function of treating and healing their patients. The only difference is that Ayush doctors are using indigenous system of medicine like Ayurveda, Unani, etc., whereas doctors under the Central Health Services are using allopathy for tending to their patients. Supreme Court opined that the mode of treatment by itself would not qualify as intelligible differential to justify such classification. Accordingly, such classification was held to be unreasonable and discriminatory. If that is the view taken by the Supreme Court, we cannot find any fault with the finding returned by the learned single judge that house surgeon and postgraduate students of Ayush institution should be treated at par with house surgeon and postgraduate students of allopathic institutions. If the latter are granted higher stipend, similar benefits should be extended to the house surgeons and postgraduate students of Ayush institution. My lord, against this SLP was preferred. SLP dismissed, my lord. Next page. Page 15 and 16, my lord.
Yes.
We do not find any reason to entertain this petition under Article 136 of the Constitution of India. The special leave petition is accordingly dismissed. Then, my lord, there is another judgment. This is by Uttarakhand High Court, my lord, that your lordships will get at page 17. This is again a division bench judgment. My lord, after referring to all these aspects, I'll draw your lordship's attention to para 11 at page 28. Accordingly, the writ petition is allowed. The state respondents are directed to pay and release the salary to the petitioners at par with allopathic medical officers and dental medical officers from the date when the same was paid to the allopathic and dental officers within a period of 3 months from today. So, my lord, this is again a judgment on pay parity, and this was appealed before the Supreme Court. Supreme Court has rejected it, my lord. That order, lordships will get at page 29. State of Uttarakhand versus Sanjay Singh. At page 29, my lord. Having heard learned counsel for the parties and considering the facts and circumstances of the case, we do not find any ground to interfere with the order passed by the High Court. The special leave petition is accordingly dismissed. However, we may only clarify that respondents who are Ayurvedic doctors will be entitled to be treated at par with allopathic medical officers and dental officers under the National Rural Health Mission scheme. After the order was passed, the learned counsel for the petitioner made a statement that the petitioner would like to file a review before the High Court. It is not for this court to issue any such direction. It is always open to the petitioners to pursue such remedy as may be available to them in law. So, my lord, at least, my lord, there are 3 Supreme Court judgments, 2 on pay parity and 1 on age of superannuation, which favors us. And 1 judgment, my lord, that is which was referred by learned single judge, that your lordships will get at page 31, my lord. Here, of course, a slightly different view has been taken, my lord, where relying upon the nature of duty, my lord, a distinction is sought to be made. Now, this was referred by the learned single judge. In any case, my lord, P.A. Bhatt is a judgment on pay parity. It is not a judgment on, my lord, age of superannuation. As far as age of superannuation is concerned, there is a direct authority of the Honorable Supreme Court. And the learned single judge has also, my lord, another argument was advanced by the state before the learned single judge, that the cabinet decision was not challenged. Well, cabinet decision cannot be a subject matter of challenge in a 226 proceeding. This issue was settled way back by the Supreme Court in that, my lord, Punjab case. Yes, huh? No. Bachattar Singh's case. End of the day, my lord, until and unless an administrative order follows from different level of, my lord, discourse, that is not the decision of the government. My lord, in the process of taking a decision, different notes will be put by different authority. It will all start from the clerk, it will go up to the minister as per the rules of executive business. Only when based on that decision, my lord, an executive order is issued, then that is what is required to be challenged. That is what was clarified by the Honorable Supreme Court in Bachattar Singh's case. Now the learned single judge has relied upon PA Bachattar Singh to reject our case, my lord. Therefore, my humble submission is, my lord, lordships can close this matter today also. It's not that I'll make any further argument on this. Or lordship may like to fix a date. I'll leave it to your lordships, my lord.
The state has been, my lord, represented by the area Assam, my lord. Okay, some difficulty. Will, my lord, argue this case, my lord, in his presence, my lord, any day in December, my lord, convenient.
So lordship will admit the petition and fix the
Yes.
matter for hearing in December.
Sir, wait, this is with regard to the service purpose. There is another cabinet memorandum which enhances the age of professors.
Yes.
Is it applicable to Ayurvedic colleges?
Yes, in government.
That can apply that. They will have to also justify this.
Man.
Why it is not applicable.
That I will have a clarification. Admit. This the matter for admission hearing.
Let it be for final disposal. Final hearing, lordship can admit it, my lord.
Matter for hearing. When do you want?
Lord, from 5th, I'll be not there. Or could it be in the new year, my lord?
Yeah. Generally, Ninth.
Because, my lord, virtually last week there is no working day. And for 5th, it start, yes, 9th January. Deeply obliged.
Mr. Gogoi, you must also give a clarification on how can you distinguish between this?
No, let me, my lord, first have the instruction whether it is same or not. If it is same, then.
My lord, the compilation, should I leave it or I again give it on the date of hearing?
You can take it back. Maybe.
I think that will be better, my lord. It might get misplaced also.
Yes, it may get misplaced.
15.
We are increasing the age of professors in all education institutions. They have also broken the Ayurvedic. Supreme Court has said it's not.
Yes.
Let me lordships. My lord, this judge writ appeal for file for the challenging the judgment and order passed by one single judge, whereby the writ petitioner was granted pay protection. Protection of pay he was drawing earlier when he was working in the Jorhat Development Authority. Subsequently, my lord, pursuant to an advertisement by the Assam Public Service Commission, he was appointed as a government servant in the Town and Country Planning Act. Now, the question that arose is whether earlier he was working in a government department, whether he was holding a civil post or not. He paid for this pay protection in terms of FR 22. Now, it is possibly settled law that unless his earlier appointment was under the government, he was holding a civil post, he cannot claim pay protection. Now, the Honorable Single Judge relied on Section 21 of the IPC to say that he is also a public servant. Now, that itself will not be sufficient. Page 16, the judgment starts. Now, page 20, para 10 is the argument on behalf of us that he is not entitled to protection of pay. Page 20, para 10.
Per contrast, the so learned Standing Council of Finance Department Assam raises the following objection. Firstly, he submits that FR 22 is with regard to pay protection. The applicability of said provision is to be read along with FR 2, as per which the FR is applicable only to government servants whose pay is debitable to the civil estimates of the state of Assam. Secondly, he submits that ROP rules would not apply unless an autonomous body specifically extends its applicability, and the mere fact that the pay scale is similar would not mean that such pay scale is as per the ROP rules. He clarifies that the ROP rules are applicable only to government servants and not to any other servants who may be of autonomous bodies. The Learned Standing Council has also referred to Section 8G4 of the Act of 1959. This is by the Assam Town and Country Planning Act, which were incorporated by an amendment of the year 2022. Under the said provision, the method of recruitment, conditions of service, pay and other allowances, etc. may be prescribed. He also draws the analogy of employees of GMDA and submits that employees of GMDA cannot be deemed as government servants. By contending that a government servant is different from the government itself, the Learned Standing Council has relied on the case of A.K. Bindal, reported in 2003 5 SSC 163. He submits that the employees of government company are not government servants and therefore not entitled to claim any benefit which are accrued from the government. The Learned Standing Council has also relied upon a notification issued by the Finance Department in Swenso, as per which past services shall not be counted for the purposes of grant of modified assured career progression scheme, MSCP, etc. Swenso and additional senior government has submitted that an affidavit in opposition has been filed on Swenso, and in paragraph 10 thereof it has been categorically stated that the earlier post concerned is not a government post. Now, in this background, my lord, Lordship may kindly turn to para 15 and 16, my lord, how this has been ultimately granted. Para 15 at page 22, my lord. Para 15. The Learned Counsel for the petitioner has referred to certain provisions of the Act of 1959 regarding the constitution of the authority, grants, advances, loans by the state government, and also audit by the Accountant General Assam, and also to Section 57, as per which the officers and staff of the authority would be deemed to be public servants within the meaning of Section 21 of the IPC. This court has further noticed that under Section 8B, the composition of the authority itself had been laid down, which would show that all the members of the authority are to be appointed by the state government, and most of them are holding substantive posts under the state government, are ex officio members. FR 22 is with regard to pay protection. Though an objection has been raised on behalf of the Finance Department that for getting benefit of FR 22, one has to fulfill the requirements of FR 2, according to which FR applies to all government servants whose pay is debitable to civil estimates of the state. The meaning sought to be assigned by FR 2 cannot be given a narrow meaning so as to exclude from its operation employees, officers under the authorities which are constituted under the Act of 1959. The aforesaid opinion of this court is based upon the judgment earlier rendered by this court in the case of Swenso, wherein it has been held that FR 22 would apply even for employees who were working in an undertaking of the state. In the said case, the petitioner was earlier an employee of the Assam Syntax Limited and later appointed in Assam Textile Institute. This court has also noted the observation of the Honorable Supreme Court in the case of R.L. Marwaha, etc., wherein paragraph 8, the earlier services have been directed to be counted. The aforesaid case, however, was with regard to claim for pension. The aforesaid notification dated Swenso, by which the officers and staff of the Urban Development Authority have been held to be interchangeable, is also in favor of the petitioner, as for all purposes, such officers and staffs are held to be at par for their services are concerned. Swenso Standing Council had contended that unless an incumbent is a government servant, is not entitled to benefits of revision of pay. However, this court is of the opinion that the issue in this case being only with regard to pay protection on being appointed under the Directorate of Town and Country Planning when the petitioner was initially working in the JDA, the said submission may not be relevant. The reliance placed upon the case of A.K. Bindal would also not be relevant, as there is no dispute to the proposition laid down by the Honorable Supreme Court regarding the difference between government companies and government itself. In the said case, the findings of the Honorable Supreme Court were with regard to protection under Article 311 of the Constitution of India, wherein a further observation was made that employees of government company cannot claim salaries from the government. Though reliance has also been made upon a notification dated so-and-so of the finance department wherein it has been laid down that past services would not be counted for the purpose of MSP. I'll read the FR 22. It's absolutely clear. One has to be a government servant, otherwise he cannot claim.
Mr. Additional issue notice. Anybody for the other side?
No, possibly after notice is issued, they will FTS.
Petitioner takes steps for some response by the within one week.
Notice, madam?
Steps, 1 week.
Yes.
This is the forwards.
But I've got an IA, possibly kindly grant a stay. Otherwise, all the persons working in even private companies, they will come for pay protection. Para 20. In view of the above, just one.
Gogo, you can appear for the pro forma respondent.
That's the side.
Finance. Mr. B. Gogo, then Mr. Finance, appear the pro forma respondent number 2. Then appealing to take steps for service notice on the respond number 1 by the state authority within 1 week. Please up to 4 weeks. Pray for a team that will consider on the next week.
The IA, I have filed for an interim protection.
That will consider on the next.
16.
May I please, Your Lordship? Lordship, in this matter, I filed an caveat, Your Lordship. Earlier, that has not been taken, Your Lordship. I may be allowed to file an impeachment.
No, Lordship, this, my friend is submitting that they filed in caveat in the writ petition and it is in writ appeal.
No, Lordship.
You are for the white.
Yes, Lordship. And originally, there was a direction, Your Lordship. Any order passed should be communicated to me, Your Lordship.
Lordship, on submission, whether in the writ appeal, whether his presence is required or not. He is my first wife and I have been dismissed from service on account of bigamy as I have.
1 minute. With the judgment?
Yes, Lordship. Lordship will find in the page number 62.
Yes.
Should I submit, Lordship?
You must.
We can.
Lordship, this normally the court does not interfere on the punishment imposed on the delinquent. That is true that the bigamy is a misconduct. When the court interferes, if the decision is disproportionate and shock the conscience of the court, only then the court interfered the punishment which is awarded by way of disciplinary proceeding in the delinquent. That is the settled law. But the word disappropriate, disproportionate, or what shocks the conscience of the court is not defined in any statute. Rather, it will depends on the facts of the case. And the record pertains to the case will reveal that I got married in the year of, I joined service in the year of 1996.
That we have seen.
Yes, and the first time marriage conducted in
You
2000.
contradicted the second marriage when the first marriage was valid, isn't it? Subsisting.
During the currency of the first marriage, I have contracted the second marriage. These are the admitted fact as the record will reveal. But my Lordship, the issue is that
Will issue notice.
Lordship.
Who appears? MS.
Yes, sir.
R.
RB.
Appears for
Respondent number 1, 2, 3.
one. Appears on behalf of all. So. List the mention. After 4 weeks.
Right.
If you want, you can file a impleading application. That will be considered.
That will consider, like you file your.
17.
Lordship, here, my lord, the medical admission rules amendment of 2023 has been presented. The AG is otherwise appearing, yes, can it be in January, my lord? Otherwise, my lord, counseling is over by September.
This year's counseling is over, now it will be as prospective.
January-
Let the date be fixed, it may be admitted and a date be fixed.
On request made on behalf of the use the matter. When do you want?
But on my request, my lord, let it be on my lord, in
Not on
January.
behalf
any
of
day.
Advocate General.
Not,
On request.
you will be
made by
assisting the department,
the Google and standing council,
health department,
health department. List on.
in the second week of January, my lord.
At the time of admission, it was earlier listed for a final disposal at the admission stage. There's an
20
order.
seconds.
Man,
Lordship, I appear for the NMC, my lord, in this matter.
Mr.
DK Boydome,
DK Hotel Council.
standing counsel for the National Medical Commission.
Appears for the national NMC.
Deeply obliged. my lord.
24 of supplementary leave admission.
To the four. Yes.
Wait a minute. My lord, the issue which arises in this rate appeal is, my lord, whether the Bachelor of Education B.Ed degree obtained by the respondent number 7 is valid or not. And this will depend on interpretation of section 14 and 16 of the NCTE Act. So that's the short issue which arises, my lord, in this case. Facts are not in dispute. And therefore, first I will, my lord, place certain dates which will be relevant for adjudication. My lord, the first is 1/7/1995, 1st July 1995, when National Council for Teacher Education Act, NCTE Act 1993 came into force. The college in question, which has given the degree, my lord, came to be established on 31/12/1995.
Which college?
This is Dr. Sasi Bhushan Institute of Education. Dr. Sasi Bhushan Institute of Education. It was established on 31/12/1995. The third date, which will be relevant, is 5th of July 1996. This is the date on which the Assam University granted affiliation to Dr. Sasi Bhushan Institute of Education. 5/7/1995. Now, the respondent number 7 passed his B.Ed in the month of June 1997. June 1997. And Dr. Sasi Bhushan Institute applied for recognition before NCTE on 12/8/1997. And then, of course, provisional recognition was granted in 2000 and final recognition was granted in 2001. So basically, my lord, the 4 dates which are important is 1/7/95, 31/12/95, 5/7/96, June 97, and 12/8/1997. These are the dates which are important. Now, if your lordship will see the impugned judgment at page 218, 218. This is our presented case, which has not been denied. Of course, one entry is wrong that I will submit how. Paragraph 4 at page 218, if my lords will see, 1/7/1995, NCT Act 1993 came into force. The appointed date is 7/8/1995. This is not correct because this is appointed date of the second proviso to section 14 of the NCT Act. So it is, and this was by Amendment Act, my lord, NCT Act, Amendment Act 2019, with retrospective effect was amended, and it relates to the central government's institution or institution funded by the central government. Then 31/12/1995, that is Sasi Bhushan College, it was established. Then 12/8/1995, 7, college applied for recognition. 13/1/2000, the college was recognized. And June 1997,
respondent number 7 appeared for B.Ed examination. Now I'll take your lordships straight to the act. I'll pass on the act.
Yes.
My lord, before I place section 14, I will first place the main provision, then I'll go to 16, and then I'll come back to proviso. Because proviso is in the nature of exception. Kindly see 14, section 14 at page 9. The pages are below mentioned below. Page 19. Recognition of institution offering course of training in teachers' education. Every institution offering or intending to offer, my lord, kindly mark it, intending to offer. So it includes both an institution which is offering, an institution which intend to offer. They are not established as yet. Every institution offering or intending to offer a course or a training in teacher education on or after appointed date may, for the grant of recognition under this act, make an application to the regional committee concerned in such form and in such manner as may be determined by the regulation. So this main provision provides that any education which is offering a course or a training in the teacher's education, or those who intending to offer, they will have to take recognition from NCT Act under this act. That's the main provision. Now I'll go to the 16, my lord, and then I'll come back to the provider. If 16, my lord, will see affiliating body to grant affiliation after recognition or permission by the council, notwithstanding anything contained in any other law for the time being in force. My lord, this is a non-abstante clause. It will override all the law on the subject, so far as this is concerned. Notwithstanding anything contained in any other law for the time being in force, no examining body shall, on or after the appointed date, grant affiliation, whether provisional or otherwise, to any institution, hold examination, whether provisional or otherwise, for a course or training conducted by recognized institution, unless the institution concerned has obtained recognition from regional committee concerned under section 14 or permission for a course or training under section 15. 15 we are not concerned. Now, my lord will kindly see, there is a clear bar or prohibition for the examining body like university to grant affiliation after the appointed date, even to the existing institution. There is a clear bar. And this bar is with non-abstante clause. Now your lordship may come to the proviso. Now this is exception to the rule. Proviso, my lord will see, may I place it now at page 9, proviso to section 14. Provided that in an institution offering a course or training, may I pause here for a second and submit. Your lordship will say, see here, intending to offer is conspicuous by its absence in the proviso. Provided that an institution offering a course or training in teachers' education immediately before the appointed date shall be entitled to continue such course or training for a period of 6 months if it has made an application for recognition within the said period until the disposal of the application by the regional committee. Now, this proviso is applicable only to the existing institution and not to the institution which are intending to offer. This will not. That is very clear. And my lord, so far as the second proviso, if your lordship can see here, well, there is confusion. 17.8 it came or it came on 1.7. So I have got the my lord, the Gazette notification. The second proviso says, provided further that such institution may be specified by the central government by notification in official gazette, which are funded by the central government or a state government or union territory and have offered a course. We are not concerned with it, but just to show that Your Lordship will kindly see the proviso, when the proviso, second proviso came into force. This is a Gazette notification of 10th of July, 1995. Your Lordship will see, in exercise of power conferred under Section 3 of Section, I'm sorry, my Lord, this is, Your Lordship is having that National Council for Teacher Education Amendment Act 2019. Yes. This, well, you'll see, this act may be called so and so. It shall be deemed to have come in force on 17th August 1995. So it's proviso, second proviso which has come, has nothing to do with my case. I mean, if your Lordship will see, when this NCTE Act came into force, the English one is in the second page. In exercise of power conferred by subsection 3 of section 1 of the National Council for Teacher Education 1993, the central government hereby appoints 1st day of July 1995 as the date on which the said act come into force. Now, therefore, my lord, my submission would be that NCT Act came into force on 1st of July 1995. Now, that is the date before which an the teacher's training must be imparted by an institution, not after 1.7. They are protected under the proviso of section 40. Now, in this case, as I have placed below, Sasi Bhushan College was established on 31/12/95, after. And it got recognition on 5/7/1996. And this is admitted. And I'll take your lordships straightway to the judgment. Paragraph 35, my lord will get at page 230. First line starts from page 230. My lord, if your lordship can have 7th line, my lord. 7th line from the top at page 231. The respondent number 7 has contended, he's also respondent number 7 here, that it was not possible for an institute to fulfill all the formalities when the requirement of the act were itself not fulfilled by the authorities. This court also noted the date of notification is 1/9/95. The regional committee was constituted on 6/1/1996, and the rules were framed under the act were published on 3/12/1997. This court also noticed that procedure for recognition is prescribed only in the rule, including aspect of prescribed fee, This court has also noted, may I pause here, Melissa? This is for the institutions which were offering the course as on the appointed date. That is 1/7/1995. This will not include those institutions which came thereafter, after the appointed date, 1/7/1995. This court has also noted that prior to coming into force of NCT Act, the degree of B.Ed was granted by institute which was recognized by SCART, that is State Council of Educational Research and Training, on 31/12/1995, which was the appropriate authority at that point. This court also noticed that the prescribed authority, that is Assam University, has granted affiliation to the institute on 5/7/1996. Now, in view of the bar contained under section 16, no question of Assam University granting recognition to an institute which came after the appointed date. Now, my lord, what single judge erred, my lord, where he erred, my lord, in paragraph 36 at page 231, just few lines I'll place. Then a single judge, my lord, held that the issue is covered by two writ petitions and also by a division bench judgment. If your lordship will come to 231, notwithstanding all the aforesaid discussions and the grounds tried to be projected by the petitioner in writ petition so and so, this is my writ petition, this court has noticed that the issue involved in the present case was exactly the issue in WPC 3214, wherein B.Ed degree of one Govind Chakravarti who was respondent number 7, was put to challenge. This court noticed that permission by the inspector of school Kachhar district was given to Sri Govind Chakravarti, was a common permission dated 6/9/96 to respondent number 7 in the instant case, as well as petitioner in so and so. The learned single judge by judgment dated 5/4/2022 in paragraph 38 held that degree is to be valid. The said judgment also has also been affirmed by the Honorable Division Bench in Writ Appeal 154 of 2022, white judgment and order dated so and so. Now, my lord, this is, with all respect, this is perverse. If your lordship can kindly come to the division bench judgment at page 185. What was the issue in the case? 185. The judgment of the Honorable Division Bench starts at page 181. And I'm referring specifically to the question which arose before the division bench at page 185. Paragraph 5, my lord. The controversy that has emerged for adjudication by this court is whether NCTE had the jurisdiction to extend the date for filing of application for affiliation. Because if your lordship has noticed, under section 14, the time limit is 6 months. And the rules could not be framed. Regulations could not be framed. There was no procedure at that moment available. No fee was prescribed by which they could apply for recognition. So the NCT extended. Now, your lordship will kindly turn to page 73. I'll show the extension order. Order dated 29th of July 1997. The typed copy is at page 73, otherwise the photo state copy is at page 75. Lordship got it. And to draw your kind attention to the fact that according to the provisions contained in section 14 of NCT Act 1993, every institution offering a course or training in teacher education before the appointed date, But there cannot be anything more clearer than this. This will apply to an institution which was offering the course prior to appointed date. And this related to them, and this was extended. The limit of 6 months fixed by 14 was extended. And the issue raised was, how can NCTE extend the date when it is provided by the statute? And that was the issue before the learned division bench. And I have shown, my lord, paragraph 5, page 185, division bench has said what was the issue before it. So the issue was not there whether section proviso to section 14 would apply to a institution which was not in existence as on 1st of July 1995, when the NCTE Act came into force. This has not been decided.
Appointed day was 1/7/90.
95.
Here it's said to be 78/90. This is the second proviso which came.
That's right, second proviso. And I have given a copy which says
1/7.
1/7.
And why is it written here 17/8?
No, this is only for the proviso. Kindly see the act that I have given. The act that I have given, your lordship. Kindly see the second proviso. And just below that, second proviso, there is a mark 1. And then see below, by Act 2 of 2019. So this provision came.
Second proviso.
Yes, with effect from 17/8. This proviso.
Second proviso.
Yes, the second proviso.
First proviso.
So, my lord, at this stage, my lord, my simple assertion will be that proviso to section 14, the first proviso, only makes an exception for existing institutions which were in existence as on the appointed date. Any institution which has come after that would not be covered by the second proviso. Therefore, question of whether the 6 months has been extended and they have applied within extended period would not arise in my humble submission. I am, my lord, still continuing as principal of Bageshwar Higher Secondary School, and I'll say that your lordship shall submit that your lordship may protect that. And there was a status quo order before the single judge.
That was vacated.
What were you trying to point out in the division bench order earlier?
Page 85, 185. There the only issue was whether NCT has the power and authority to extend the date which were fixed by section 14. Your lordship will see just 1 minute, section 14, I'll show you. Section 14. Proviso. Provided that an institution offering a course or training in teacher education immediately before the appointed date shall be entitled to continue. They will continue, my lord, provided such course of training for a period of so and so, if it has made an application for recognition within the said period until the disposal of the application. So within 6 months. That has been extended by NCTE. And that was challenged in the writ petition, and then it ultimately went to the Supreme Division Bench, and Division Bench upheld the judgment. My humble submission is this question which I am raising was not there. Was not added. That's why I have taken your lordship to paragraph 5 of the Division Bench judgment at page 185. So your lordship will examine Whether, and also your lordship may protect.
Yes, Goswami. You are appealing for?
Caveat, lordship, respondent number 7. I'm giving the list of dates, lordship, what they have been projected.
Yes.
Lordship. Lordship, it is admitted position that NCT Act has been notified in the Gazette on 1/7/1995. And regional committee was constituted by notification 13/12/1995. I gave the notification. And regional committee has been notified in the Gazette on 6/1/1996. And first NCT regulation notified on 24/2/1996. Thereafter, Lordship, NCT rule notified on 3/12/1997 the procedure for filing application for recognition. And Lordship, the letter to the Deputy Commissioner NCT, Deputy Secretary NCT to the Assam University for applying for recognition to the institute which are offering and affiliated by the Assam University. That has been already placed by my learned senior lordship. This issue regarding B.Ed degree, one of the private respondents, along with me, was challenged in early writ petition before the Honorable Single Judge. And Honorable Single Judge, by judgment dated, lordship will find page 152. Page 152 is the judgment by Honorable Justice Surana Lordship. Same issue that has been annexed to the petition. It starts from 155.
Not the same instance. Not the same instance.
Same issue, Sociation issue. Sociation issue.
Yes.
Lordship, herein, Lordship will find page 176.
One.
Before that, Lordship, I will take note 175. Para 34. May I read, Lordship? Moreover, the petitioner has only assailed the B.Ed degree of the respondent number 6 and 8 as invalid. Nonetheless, although respondent number 5/6 has pleaded that NCT Act had granted extension of time for application to be filed for recognition up to 18/8/97, height communication dated 29/7/1997, annexure C of the affidavit in opposition, filed by respondent number 5. Said communication has not been assailed. Lordship, very important, Lordship. The communication by which the extension has been given has neither been challenged in the present writ petition nor in the early writ petition. Moreover, in absence of challenge to the take decision of the Executive Committee of NCT in the second meeting held on 17/10/97, to extend the date of making application for recognition, court is unable to hold that decision of NCT to extend the date of making application for recognition till 18/8/97, which can be presumed to be sort of post facto approval, cannot be said to be not in accordance with law. One such communication dated 29/7/97 was made to the Assam University for circulation among the concerned college. It would mean that the period of 6 months provided in proviso to section 14 NCT Act stood extended up to 18/8/97. Before that, Lordship, contrary affidavit was filed in the earlier petition. That has been discussed in para F, Lordship. And that has been already, they have made apology before this honorable court, and court had accepted that. After that, Lordship, para 38, the point for determination is answered in negative and against the petitioner on WPC case number 3214 of 19 by holding that B.Ed degree of the respondent number 6, 7, and 8 is not liable to be declared as invalid. Lordship, that has been declaration has been given, and thereafter, Lordship, writ appeal has been filed by this writ petitioner that has been affirmed by the writ appeal, Lordship. Thereafter, they have filed SLP before the Supreme Court, and Supreme Court also not granted any stay order, and that has been dismissed as per my information. SLP filed by them also dismissed. That has gone brought on record, but that I have got the information that has been dismissed, and no stay order has been granted by the Honorable Supreme Court. Lordship, thereafter, present writ petition has been filed after single bench judgment. They have obtained a status quo order. Immediately, I have appeared. I have filed an application for vacating this stay. In the vacating stay, Honorable Court held that I will hear the matter, not the stay vacating petition. Ultimately, the Honorable Court heard the matter finally and decided that B.Ed degree of the petitioner has been held to be valid. Now I'll take a Lordship. How, Lordship, the rule has been framed. I have annexed the rule also, the NCT rules, Lordship, list of dates. That is a page 8 of the list of dates, Lordship. That was a communication to the Assam University. List of dates, page 8, to the Registrar of Assam University. I am to draw your kind attention that in according to provision contained in section 14 of the NCT Act 1993, every institution offering course or training in teachers education before appointed day has to apply for recognition to the concerned regional committee NCT Act within a period of 6 months from the date. Provision of the state are applicable to all colleges and Department of Education and all universities offering B.Ed and other teachers education courses. It is mandatory for all teachers training institution to obtain recognition from NCT due to lack of information, very important. Due to lack of information about the procedure, many of the colleges and Department of Education did not apply for recognition within the stipulated time. The procedure and norms of standard of recognition have already been notified in the Gazette of India by the Council in order to provide the fresh opportunity for non-applying college and Department of Education. Last date of received application for the 4 regional committee of the Council has been extended up to 18 August 1997. In accordance with the provision contained in section 14 of NCT Act, after 17 August 1990, no examination ban can affiliation, provisional or otherwise to any institution to hold evaluation of the provisional or otherwise for a course of training conducted by institution unless institution concerned has obtained recognition.
Became Mr. Lena City Council. Assisted the Mr. R.S.I.K. really concept issue notice.
Lordship, I have only 4 months of service. He has 7 years of service. And because of the stay order, I am not getting the benefit of, I am the selected one, Lordship, serial number 1. I am not getting the benefit of promotion. So there should have been a stay order. Lordship has finally heard the matter. Lordship can finally heard the matter. There should not be any stay order.
Who appears?
Any reply will be required because we have not touched the issue.
We have, Lord is fixing the matter. We'll fix the matter shortly.
Education?
Finally.
And then till then, my lord, I.
He does, the standing council, school education department appears for respondents. 1, 2, 3, 4, 5. 3, 4, 5. 3, 4, 5. And Mr. Ayala. 6. The next standing council NCT appears for number 6. Mr. Kuswami, the council appears for the respondent number 7. Public comment. So, list the matter on December.
After 7, anytime.
The militant parties are directed to maintain status quo will do Yeah. Will shall maintain status quo as on the.
Till then, my lord, let the reader.
Status quo is.
Obliges.
One that argument by Kenya has taken. That whether it's an existing institution.
Lordship, that.
That
Understand.
has to be touched on.
That has been clarified in NCT Act itself.
No, fine.
Lordship,
On
no,
that
no,
day-
Lordship.
that day you can-
Lordship has,
On that day you can.
Lordship, only thing is, Lordship, I can point out one thing. Lordship has not gone to the NCT Act directly. NC Act has given a specific provision in the NCT Act itself.
Later, not today.
No,
Only I will place, Lordship, that section 34.
Later.
Provision of remove difficulties.
Not today. I've already passed on it.
There is a specific
How late
provision
now?
giving to the NCT. They can do anything for this period, Lordship, transitional period. Section 34. Apply this.
Yes.
May I please your lordship? Lordship, this is a matter related to eviction. We have approached this appellate court because of three reasons, my lord. Because of the observation made by the honorable single judge. My lord, the first observation that for which you have made in contention before this honorable court, appellate court, is that the learned single judge has observed that. So basically, these are the people who can be segregated on two bases. First is that few people have been PMAYG beneficiaries, and the other who have been not been PMAYG beneficiaries, my lords. For the appellants who have not been the PMAYG beneficiaries, my lords, the learned single judge has made an observation that the appellants other than PMAYG beneficiaries doesn't have any house over the land which is sought to be evicted. Now, my lord, it is my humble submission that when a constitutional court makes an observation, it has a far-reaching impact. Therefore, my lords, I want to take my lords to the to my appeal and show it to my lords that we have annexed enough evidence to show that appellants other than who are PMAYG beneficiaries have also house over the land. If I might take to my lords the page number 88 of the appeal, my lords.
Final conclusions of your honorable single directions.
There is-
Place that. Directions of your honorable single.
Direction.
Two to
Direction. Yes, my lords. There is in page 11 of the
227. Page 227. Para 20. Of your paper. The directions.
Yes, my lords.
Para 20 on those. Page 226. You can just place that.
Yes, my lords. Insofar constructed by the four petitioners under PMAJ scheme, it appears that houses were constructed sometimes around 2007 to 19 by availing an assistance under PMAJ scheme to tune of so and so, and therefore taking into account the inflation efforts in construction of houses, the inconvenience that should have cost the four petitioners for shifting their houses, as well as the stand taken by the learned Advocate General Assam, they would be suitably compensated. This court is of the opinion that for the ends of justice, a direction is required to be issued by this court to pay adequate compensation to the four petitioners, my lords. So, therefore, this writ petition is being disposed with the following observations, my lords. That all writ petitioners should be allotted land in the adjoining area by issuing separate allotment orders if not already done. And then four petitioners should be having PMAJ husband will be paid an amount of 3 lakhs. And then an eviction order should be done. So, my lords, my grievance here is that, my lords, if I take my lords to the para 8.
Para 8 of?
Just a second. My lords, para 10 of the judgment, my lords. Para 10. Para 10 of the instant order, my lords. Read petition conjunct from the last one. Read 022. Read petition conjunct from the. So, my lords, in para 10, para 3 is in the. No, I'm so sorry. I'll just take 2 minutes. Melody is para 10. Sorry, Melody. Para 10. So para 10 starts that it has been noted herein above. It is not in dispute that all the read petitioners are in occupation of Sarkari land. The land in the occupation had never been allotted in the favor. From the documents annexed to the counter affidavit filed by respondent number 2, it appears that out of 15 petitioner, only 4 petitioners, so-and-so, had constructed dwelling house by availing the grain under PMAJ scheme to the tune of 1,30,000 rupees each. There is nothing available on the record to even remotely indicate that save and except this 4 petitioner, any of the remaining petitioner had made any construction over the Sarkari land. So, my lord, our grievances against this observation might be made by the single judge is that, my lord, we had constructed house over the land, and that was also recognized by the the affidavit in opposition of the government in the read petition as well.
Para 11.
Sorry, my lord.
Para 11. Read para
11 now. 65 now. Yes, my lord. From the pleading contains in the read petition, it is not clear as to how the petitioner could construct permanent dwelling house over a plot of Sarkari land with PMAG funds without obtaining the approval of district administration. It is not in dispute that the 4 petitioner had availed PMAG funds to construct the house. It is therefore difficult to presume that such construction took place without the knowledge and approval of the concerned official, including the respondent number 2. B.Ed as it may, it is not in dispute that the land occupied by the petitioner is required as to complete the construction of the mini stadium at Naharkatia. The stadium is intended to provide a sporting arena for the residents of Naharkatia and adjoining areas in the district of Dibrugarh, and therefore undoubtedly a project meant for greater public benefit. Under the circumstances, if the Sarkari land under the occupation of the read petitioner is required by district administration for construction of the stadium, the said process, if carried out in accordance with law, cannot be obstructed by filing a read before this court. Therefore, the only question that will arise for consideration in this read petition is to whether the respondents are seeking to take over possession of the land by following the due process of law or not, my lords. So, my lords, I have also have made an contention before this appellate court that, my lord, what we have to decide, what my humble submission before this honorable court is, because, my lord, Pradhan Mantri Awas Yojana Gramin houses are being constructed over many parts of Assam. Now, my eviction process has been carried out in many parts of Assam where Pradhan Mantri Awas Yojana Gramin houses are also being.
Read para 20.
Thirdly, since the petitioners are occupying Sarkari land without having any document of title, and considering the stand of administration, they are willing to allot Sarkari land to the petitioner so as to mitigate their suffering. This court does not find any justifiable ground to keep the read petition pending any further, thereby obstructing the construction of the mini stadium more so when the SDLC has approved the proposal for allotment of land to be made in favor of petitioner in adjoining area covered by the same documents. So, my lords, what my humble submission before this honorable court is, first that the, my lords, this observation by the learned single judge that appellants other than the PMAG beneficiaries have not constructed land over the land. We have ample evidence before in the read petition and in the affidavit in opposition filed by the government that there are houses that has been constructed by the other appellants as well. That's my first submission. Second submission before this honorable court is that when a person constructs a PMAG house over the land, when it's sanctioned by the government by the government and all the nodal authorities, whether a person becomes a bona fide user of the land or not. That is my second submission. Third submission is that, my lord, when a person is being evicted and being allotted the land, for that example, now, my lords, in Assam, a place which is prone to flood areas, my lords, there are waterlogged areas. So if we just allot a land of people who are landless and who relies on subsistence income, whether a compensation should also be given to that effect or not, Because whether just by allotting a land, whether right to life and liberty will be secure or not, that's my humble submission for this
I
honorable.
don't think this is with nothing. Yeah.
You are talking about the PMI rights. The Honorable Single Judge has clarified that a person who has constructed that PMI house could not have done it in that area without the approval of the authorities or without the knowledge of the authorities. For that purpose, for that limited purpose, the state also agreed that we are compensating them to that extent. But that compensation cannot be extended to you because merely you have constructed a house in a Sarkari land. You have to be evicted. The thing is here, the difference with the other evictions and this is that they have given you alternative.
Yes, my lord.
Then what more can you ask? What right do you have to ask for more?
Yes, my lord. If I may produce a judgment of the Delhi High Court.
No, come to the Assam High Court. Our laws here, our Assam laws.
My lord, there are various judgments of the Supreme Court.
Tell me one law which says that if you are evicted from the land,
yes, my lord.
Our land laws does not provide even for the alternative thing.
Yes, my lord.
Here, they have given you an alternative.
Yes, my lord.
Even before eviction.
Yes, my lord.
And the Honorable Single Judge has protected you.
Yes, my lord.
Saying that do this and thereafter 15 days notice.
Yes, my lord.
What more can you ask?
My lord, for that, we are just praying before this honorable court and adequate compensation be provided. Because
What compensation?
What right of yours have been violated?
no right, my lords. No, what I'm saying is that Honorable Single Judge is that, my lord, it is in the low-lying area. On that, I'm on a narrow ground. But what my main principle on which I'm who I have appealed this single judge order, learned single judge order, is because, my lords, the learned single judge has not decided whether a person on account of construction of PMAYG houses has become a bona fide user or
No,
not.
he has not said that. He has said that because that person has expended some money there under a government scheme and the government has given him that house, that money, that shows that they knew that it was a Sarkari land it was given. To that extent, it said that, okay, fine, you provide him some compensation.
Therefore, my lord, we have filed in, my lords, if I may.
In fact, my lord, if your lordship go through the paragraph 7 and 8 of the affidavit in opposition filed by the state, and no reply has been filed against the affidavit in opposition filed by the state by the petitioner in
That
the
has been
petition.
noted by the Honorable.
My lord.
My lord, we have done that
7
because,
and 8, an agreed position in paragraph 8, my lord, by the petitioner, they agreed to shift a plot of land which has been allotted to them. In fact, they have accepted the allotment. This is the documents we have, my lord. They have accepted the money which has been, my lord, provided to the four petitioners who constructed their houses. My lord, that has, after accepting all these things, as directed by the learned Singh, how this writ appeal is maintainable?
if I may, my lords. My lord, I'll just take 2 minutes time and I'll wrap up, my lords. I'll not
No,
take
no,
more than 2 minutes.
you've accepted the plot of land, isn't it?
No, my lords, no
You've been-
demarcated land.
You
My
have
lords,
been allotted the plot of land, correct?
we have been given allotment certificate, my lords. We have been
Then
given allotment
fine.
certificate.
So, after completion of 1 and 2, para 1 and 2, they have to give you 15 days notice, and if you fail within 15 days to vacate the land,
lords,
then
they
the
have
eviction
come to our
process will
house.
proceed.
I
So
understand,
that is what the learned single just said. So they've complied with 1 and 2, then they issued 15 days notice.
In fact, those four petitioners who have accepted the money of rupees 3 lakhs, they have also filed this writ petition. How they can?
My lords, what has happened that they have come with the police officials to our house. Sorry, my lords, I'm making oral observation on that to give us the allotment letter and to give us the set check. My lord, we have also taken into account that these are poor people which have been approached with the police officer along with the where circle officer has approached them along with the help of the police officials. However, this is my oral submission because there is no evidence to the record, my lord. They could not keep any evidence. However, my lord, allotment certificate, we are grateful that allotment certificate has been given, my lords, to the other appellants as well who did not have PMAOG houses. However, my lord, if my lord goes through the the allotment certificate, my lord, they have not demarcated any land. So what a problem that has happened at my lord, they cannot even see which land has been allotted to them, my lords. If my lord goes through the allotment certificate, my lords.
Consolidated.
pass the judgment? Or the chambers? Okay, we are closing this with them.
Yes, my lord. Much obliged.
Dismiss.
Much obliged, my lords.
Obliged.
Much obliged, my lords.
Yeah, just one, two.
26.
May I please, my lord? My lord, this matter is led by senior counsel, Mr. Aichur. He's on legs, my lord. Perhaps matter will pass off for a time being.
My lord, actually, we have filed our wakalat. It will be day after tomorrow. In fact, we got the copy while coming to court. Friday, my.
Tell Mr. Chaudhary also, there is a liberty given here.
My lord.
If you can explore that liberty before
Hmm.
the proceeding. Let's ask.
In fact, whole matter can be heard. A very short point is in. In fact, my lord, we got the copy coming to court. Of course, we didn't file caveat when we informed them that if it is not inconvenient, day after tomorrow, my lord.
This the matter again on
Friday, my lord.
17th.
Lordship, can it be tomorrow, Your Lordship, actually,
Friday, can you some-
in this matter?
Okay, tomorrow. My learned friend has some difficulty. I'll come for the first step.
16th.
Deeply obliged.
Eighteen of Delhi list.
All right.
May I please?
Yes.
This Millot appeal has been Millot referred against the water dated 3/10/2023 Millot passed in a contempt case.
Provision is. Under what provisions have you
That is Millot, section Millot 19 Millot of the contempt.
19 says what?
Millot, any appeal shall lie as a right of any person, the decision of the High Court exercising its jurisdiction to punish for contempt. But Millot,
Provided there is a punishment.
no, Millot, in this case, Millot, I am the petitioner. Millot, appellant was the petitioner. But the
19 provides an appeal,
Millot,
provided there is a punishment.
punishment. And in this case,
Your appeal, your contempt was dismissed,
dismissed with Millot cost Millot.
whatever it is.
Millot.
Then,
Millot, since Millot, there is no Millot, other provision of Millot.
so there is no appeal.
I am only Millot agree by the Millot cost of the Millot case Millot because it is Millot observed that it is misuse of Millot contempt. That is your lordship may kindly, my lord, turn to page, my lord, 71, my lord. Paragraph, my lord, 5. The contribution neither can be allowed to be invoked by any of the grievance parties merely on a premise of a slight aberration by the officials in their acts, unless it is also shown that the intent and purport of such act is to willfully and deliberate violate of the words of the court order. Nor a contempt jurisdiction can be allowed to be invoked merely to achieve the purpose of the litigation or the other by making it short to democrats to be hanging over the head of the respondent government authorities, that unless the orders are passed to the complete satisfaction, the litigant would invoke the consequences of a contempt jurisdiction, which may ultimately lead to evasion of the alleged contempt. It is only because, my lord, I filed a, my lord, writ petition against that order, my lord. That may not be, my lord, and on the date of motion, my lord, it was, my lord, dismissed with court, my lord. Was not.
You have to satisfy us.
Yes, my lord. Then, my lord, subsection 3, my lord. Any person, my lord, agree by an order against who is intends to prefer an appeal, the High Court may also exercise.
Again relates back to one end.
Yes, that is fact, my lord. And my lord, I will think about the matter, my lord. After 1 week, my lord, I will.
On a question made by a kind to the council for applicants, list of all.
After 1 week, my lord. Okay.
19.
The condemnation petition, my lord, there is a delay of 56 days. My lord, what happened, my lord, consequential order has been passed. Against which, my lord, I have preferred this connected appeal, my lord. So lordship may take up appeal, my lord, by considering the delay, my lord.
Yes.
Lordship, I am appearing on behalf of respondent number 1, Lordship. I have objection, Lordship. Lordship, I am kindly pass for 1 week, Lordship. To file bigger objection.
You want to file your objection?
Objection, Lord.
Then let her
My
file.
lord, this will delay my case because my lord, consequential order has been passed. I have been directed to be removed, my lord, reverted back to the post of LDA from the post of teacher, against which, my lord, I'm working since last 30 years.
Mr. Saikia, we can't get into the merits unless the condemnation is condoned.
Yes, my lord, that is true, my lord, but my lord, they are delaying the matter, my lord, there is nothing more than that, my lord. They are also, my lord.
You are appealing for the first time.
Lordship.
She's appealing for the first time.
Yes, my lord. Next Wednesday,
But
lordship
I
will see it
cycle
over.
and counsel for the applicant. MS
D Deca.
D Deca.
D Deca. I have the local number 2, Lord.
Learned counsel enters appearance on behalf of this one. And press for week's time to file objections. Reserve list up to 1 week.
Lordship, it's fixed on next Wednesday, my lord.
You want the date?
Next Wednesday, my lord. My lord.
I'm appearing for secondary education, Lord.
MS.
If you.
20. Hearing.
Your lordship, on the last date, a last opportunity was given to the state. That whether they have implemented the section 15 or not.
It will do. My lord, on last occasion, the petitioner contended that, my lord, they have not been registered for this Ayushman Bharat Pradhan Mantri Jana Arogya Yojana because they don't have the ration card, my lord. So they were not allowed to get registered under this scheme, my lord. So regarding that, my lord, I have obtained the instruction, my lord.
What does it say?
It says that, my lord, number 1 point, Ayushman Bharat Pradhan Mantri Jana Arogya Yojana is a central government health insurance scheme which provides cashless medical benefit up to ₹5 lakhs per family per year in AB, PM, JY, and panel hospitals to Aadhaar-linked National Food Security Act beneficiaries as per defined medical and surgical packages under the scheme. Any person included under NFSA and in possession of an Aadhaar card is eligible to avail the cashless medical benefit under AB, PM, JY. The eligible Aadhaar linked NFSA transgender persons are also included in the ambit of the scheme. Ayushman Bharat Pradhan Mantri Jana Arogya Yojana is a Government of India health insurance scheme. As mentioned above, ration cards and Aadhaar cards are mandatory documents to avail benefits under the scheme. Any additional beneficiary addition would require permission from Government of India as well as the data under ABPMJAY is being pulled from the NFSA, National Food Security Act database, and the entire system is electronic in nature, and so no new beneficiary outside the list of NFSA can be added by the state. Because on the last occasion, the petitioner contended before this honorable court that they don't have ration card, that's why they have not been registered. But now, my lord, we do not have any authority, being the state, my lord, because it is a central government sponsored scheme. And the person who is registered under the NFSA Act, only they are entitled, my lord. And next paragraph, my lord. Now, something has been done for the transgender person also, that is under process. As communicated by the National Health Authority, by their letter number so and so, NSA and Ministry of Social Justice and Empowerment, Government of India are planning to extend comprehensive healthcare benefits to transgender persons under the broad name of ABPMJAY Smile. Transgender Suraksha Scheme. This scheme intends to provide healthcare benefits up to rupees 5 lakhs per beneficiary per year to all transgender persons living across the country. ABPMJY Smile covers treatment based on ABPMJY health benefit packages along with additional 50 specific packages related to sex reassignment surgery. Ministry of Social Justice and Empowerment, Government of India has identified 149 hospitals across the country that offers SRS treatment facility, and steps are being taken to onboard such hospitals for ensuring availability of SRS packages for beneficiaries of ABPMJY Smile. Guwahati Medical College and Hospital is included among the 149 listed hospitals. So their first contention that, my lord, because of not having the ration card, they were not enrolled under the scheme. That regarding that, my lord, it is a central government scheme. The persons who are registered under the NFSA Act and who's because their database, the Aadhaar card and ration card is necessary for the database. Only for those persons this can be registered, my lord. But now, my lord, the project Smile, that is under process, my lord. If that comes, my lord, they will be benefited, my lord.
Five. Based on
Yes, Mr. Chaudhary. How can we resolve this issue? Now the state government is saying they have no.
Lordship, my friend has given me a copy of the instructions today now. But so far as this case is concerned, if I may take your Lordship to my affidavit filed in September 21. Now the data goes in 2011, the category was, so far as the other sex is concerned, it was others. Others include PG also. And as per the data provided by the state, at that point of time was concerned, Lordship, there were, Lordship, 89 beneficiaries under the other category. Male, female and other. Other will include PG also. And as per the records available to us at that point of time, only there were 6 PGs. Now, if there is another scheme, Lordship, this scheme my learned friend is submitting about, this is yet to come. Something. But otherwise, if your Lordship will see what is the prayer made in the PIL, what is the prayer made in the PIL? There are only 2 prayers at page 16 of the petition. First is the Department of Health and Family Welfare, Government of Assam should establish a separate transgender health and grievance cell with an expert in transgender care and transgender representative to address the various health related issues of transgender. As per submissions made by my learned friend, Lordship, already a separate, Lordship, ward has been opened where there are a specialized team of doctors available. And the Ministry of Health and second prayer is the Ministry of Health and Family Welfare, Government of India should be directed to include the transgender community. There is no dispute on that. We are not saying that we are not going to include. In fact, as per our earlier affidavit, as per the data available with us, at that point of time, 89 were others, 6 were stated to be TG. The scheme benefits are available to them. But my instruction as of now, this is pertaining to 2011. It was, and this is, of course, this case has been filed prior to the act coming into force. Now, in the coming Lordship, the census, 2011 was, of course, a different, where they had put only others. Others included so many categories. Now, for the next census operation, there will be a specific column for the transgenders. So gradually the system will come into place. Of course, as
we'll continue at 2.
Prayer made in the PIL, Lordship. Now, while dealing with the PIL, Lordship, will just bear in mind that this PIL was filed prior to coming into force of the Transgender Rights Protection Act that came in 2019, last month. Now, under the act, there are certain directions to the state government as well as the central government, which are mandatorily to be complied with. And if we go by the mandate of the act, Lordship, the duties which are incumbent upon the state authorities and the central authorities, they have to follow. There is no escape from them. Now, if you fall back on the prayer made in the writ petition, so far as the central government is concerned, should be directed to include the transgender community of Assam by enrolling them under the scheme of Ayushman Bharat.
But we can expand the scope of the PIL.
Lordship can. The specific prayer here is for inclusion, which we do not deny. Because we get the data from the state. As per the data, whoever is eligible is eligible. I will not say that we are not going to give.
But the prayer has been, a submission has been made during the course of argument on previous occasions. That this particular surgery should be included, which my friend was insisting upon in the scheme. Now, when there is a scheme already enforced, it is not possible that it can be reframed again. Not now. The scheme is for a particular purpose. Whatever is included in the scheme, they can have the benefit. I'm not opposing.
And what do you see about this? The instruction that Mr. Devi Bora.
Lordship, I have received it today. I need to follow it up with the central Lordship. He has given it to me today, Lordship.
Particularly clause 4.
Yes.
5.
These are in the pipeline planning.
6 also.
No, this will be a different scheme altogether. It is ABPMJAY SMILE. Once this comes, that can be included, but not in the present state of things.
So when is it coming?
That I have to take the instructions.
That's what you want.
Now, your lordship, the submission made by the other side is completely an absurd. Your lordship may just see the order dated 25/2/2022, where I was allowed to amend the petition. Initially, there was only two or maybe 3 prayers, but now it has been extended. The prayer has been extended and the amended petition is before your lordship. First. Order dated 25/2/22. And in compliance to that order, the amended petition was filed on 2nd of March 22.
Amended PIL.
Yes, your lordship.
Copy of the amended PIL.
Filed an application for amendment.
Yes, I got disposed of, and then I was allowed on 25/2/22. I was allowed to amend the petition.
When did you file?
By then,
When did you file your amended PIL?
on 2nd of March 2022.
We don't have copy of the amended application. Yes, sir.
It's not placed with the record.
It's on cost.
That's the office.
You have copies of the amendment?
They have been served. They are making continuously, they are making such kind of dramas in each and every day.
We don't have the amended application also.
But on the last occasion when Justice Sandeep Mehta, he took that petition and the hearing was done, your lordship.
Lordship, I
Just check up
I,
if this
I,
is the
I
amended.
just stand corrected, Lordship. In fact, Lordship, a copy
He has the copy.
has been served, but it's on top, it's not written amended. Therefore, I was
Okay,
reading.
on top is not written.
Now, so far as my rule is concerned, Lordship, the prayer made in the original repetition and here is the same.
No, not at all, your
Yes. Please come. Please come to 4. Please come to 4 in the amended petition. Go through your petition, then you make the submission. In the original writ petition, Lordship, I am just reading out, Lordship. Original writ petition, the Ministry of Health and Family Welfare, Government of India should be directed to include the transgender community of Assam by enrolling them under the scheme of Ayushman Bharat as beneficiaries. And in the amended petition, which Lordship, the same prayer.
1 minute.
No. It's 29.
Yeah.
Yes. So your lordship, what they are submitting is to that after the filing of this PIL, they got the act in the year 2019. 2019 is the much later exercise that was been done by the government of India. Prior to that, they came up with some rubbish act, which after the opposition they faced, then they changed in 2019.
Lordship,
But prior to the 2019, your lordship will see.
He cannot use those words.
But in prior to that, in 2019, 2014, Nalsa judgment was into place. And your lordship continuously using my pronoun as a he is also a criminal offense under this act.
Achha, okay, then the government has come out with the instruction. Mr. Chaudhary, you can take my
Your lordship, you may just see the newly advisory that has been issued by the National Human Rights Commission pertaining to this health issues. Now your lordship may just see the advisory, the column healthcare. If your lordship permits me to read. This column goes with set up medical board at the district level to assist transgender. If your lordship has fine.
Yes.
Then in every district civil hospital, necessary provisions to be made for consultation, treatment, counseling for sex reassignment surgery. And the following steps may also be considered. A suitable amount may be provided to the members of the transgender community who want to opt for sex reassignment operation or free sex reassignment surgery in government hospitals may be provided. This was not at all been done. Secondly, the transgender treatments and surgeries are a part of the guidelines what WPATH says. WPATH means World Professional Association for Transgender Health. Your lordship may just see section 15 of the Act, Transgender Person Protection of Right Act 2019. So here it is clearly says that bring out a health manual related. Bring out a yes, your lordship.
They have come up with this instructions.
But that I will clarify.
The only reason why you are not getting it is because you are not covered under NFSA.
Yes.
Right? If you're covered under NFSA, you get those benefits, at least something of that. Something comes to you. So you have nothing, something comes. Let the government come up with central government come up with an answer to this, because that's the only reason. And if that continues, even under the new scheme, you are not going to get anything.
No, your lordship, there are certain other discrepancies.
We'll come to that. We'll come to that one by one. Come to that one by one. We are asking the government to take a call on that and to see how they can redress that. So that the benefits which should flow to you actually flows to you. And those technical barriers, if any, if they can be removed or lowered. Let them have that instruction. That's what my lord wants. Let them have that instruction, let them come back, and thereafter we proceed. Let us first get this cleared. If this is cleared, this advisory also is met. Right?
Yes, yes, but your lordship may just say again what discrepancies.
No, I got it.
At one, that
Got the
that
discrepancies.
NSSA, the food security scheme, that again has to be linked with Aadhaar.
Fine. You have an Aadhaar.
No, but your lordship, there is only the difficulty.
That's what I'm saying.
That's
what
why
we want them to
let them come
take a call.
up with the instructions.
Because it's a scheme, it's a policy. So they'll have to take a call.
Okay,
Let them do that.
petitioner in person,
Because policy, your lordship cannot supersede the act.
Mr. D.B. Bora has produced a letter dated 25/10/2023, written by the Chief Executive Officer, Atal Amrit Abhiyan Society, containing certain instructions which are extracted here and below. A to A. Mr. Arkadev Dev Chaudhary, the Deputy Solicitor General of India, pressed for some time to enable him to receive instructions and how the respondents in the Union of India are going to redress the said issue. Praise allowed. When do you want it? 2 weeks?
That's fine.
List after 2 weeks.
List after 2, but one more line your lordship may just take into account that many times, whether in any matter, not on this PIL, many times my pronouns are being misused.
Yeah,
And
that part.
yes,
Let us be careful on
and your lordship, recently the Chief Justice of India has issued one advisory last year in the month of November that how the transgenders pronouns are required to be dealt with, or otherwise they should be penalized.
that we should be careful. Let us be careful. on
Because
that.
in the flow. But next time we.
21.
May,
It's okay. Yes, Mr. Saran.
may please also, though my lord, in the hearing, my lord, it has been listed, but there is a IA, my lord. IA should be required to dispose of, my lord. IA 2136, my lord, been filed, my lord, to implement the opposite party 11 to 36 in the PIL, my lord. Because, my lord, until unless those opposite parties are met party in the PIL, my lord, the
11 to
36, my lord. Original respondent is up to 10, my lord, page 13, my lord, of the IA. From 11, my lord, the elected member of the council, my lord.
Yes.
My lord, notice should go them, they are the elected representative, my lord, they may file the objection about implement as they have said there, my lord.
Counsel for the petition. For the applicant. We can implement them. Yeah, we can implement them this by this application. Also heard Mr.
J. Sutia.
J. Jutia, and standing counsel.
KAC.
By this application, the applicants are praying for impeachment of respondents 11 to opposite parties.
11 to 36.
As party respondent number?
My lord, it will be my 11 to 36 also in the PIL.
11 to 36?
Yes.
In PIL number 15 of the executive. On the result of the function in the present. I is disposed. In the main PIL, in view of order passed today in the IA number so and so, let's. So and so be implemented as party respondents 11 to 16. 11 to 36. Issue notice on the newly implemented respondents 11 to 36. Petitioner to take steps for service of notice on the respondents 11 to 36 by the registered post within 1 day.
Lordship, I may pray, my lord, that I may be allowed to serve the notice to the principal secretary of the KAC, my lord. if Lordship permit.
They are the elected
That will be
representative, they have
difficult.
to file it.
My lord.
Please, Doctor, 4 weeks. In the meantime, petitioners shall also file an amended post title.
Well,
Amended PIL, my lord. They have already amended the PIL.
The
also,
post
my lord.
titles, including those names.
Post title and the
Post
PIL.
title.
Within the period of 1 week from today. 1 week.
My
within
lord.
1 week.
My lord. I love this one.
22.
Lordships, may I please, your lordship? In this case, we need some accommodation, lordship. We are not prepared for hearing today, lordship.
Yes, Chaudhary.
My lord, actually, this matter is very important, my lord. It's very important. The subject matter is also very sensitive, my lord. So what I was thinking, subject to what your lordship may say, I can start a bit, my lord.
Lordship,
Or in any case, it will take some time, my lord.
This bench will be only for 2 days.
Oh.
From Monday, Justice Nair is going on.
Oh. Or can we have the next Wednesday, my lord? At least it will not end in a day, my lord. At least we can start.
Yes.
Wait.
I heard Mr. K. and Chaudhary, let us senior counsel.
What was the
Mr.
not to next week, Constitution Bank?
No. Next Wednesday, Lord.
Assisted by Mr.
R. Sinha.
R. Sinha.
Stop.
Yes. Yes.
On request made by MS. Is the matter again on? You want it when?
With next Wednesday.
Wednesday is not a hearing day.
My lord, I wish to start it, my lord, so that it can spill over to Thursday.
22nd.
Yes. No, in fact, I have also checked out regarding the availability of Advocate General. They say that's why, my subject to lordship's convenience.
Item 1 of daily list order.
Take up item 1, just 2 and 3. Saikya, just a minute. Majumdar, this item 2 and 3.
My lord.
Do you have any instructions?
Yes, my lord. I had a discussion with, I had a discussion, my lord. One of them, they have agreed to post the writ petition on the.
Yes. In case they have taken a resolution, the resolution 9. We have no given on that, whatever we have played, the prospective effect. They have taken into consideration on the view of this resolution. Also, may close resolution 9.
Your case.
Yes, my case.
For his case.
Not
so far, my lord, I am satisfied by, I don't know whether my client will satisfy or not. So I will take some time to inform him. If he agrees, then it's okay.
Resolution number 9, if lordship has. Resolved that the date of effect of the penalty of compulsory retirement imposed on so right order dated 10/16 stands modified as 28/10/16 instead of 31/12/2004. In view of the above modification, Sri so-and-so would be eligible for enhanced pensionary benefits to be calculated on notional continuity in service till 28/10/16. Resolved further that henceforth, accepting the pensionary benefits to be calculated on notional continuity in service till 28/10/16, Sri so-and-so will not be eligible for any back wages, salary, any form of allowances, or any other financial gain for them. But what had happened is they were terminated from services. They had challenged it before this honorable court. It matter was remanded back to the authorities. The authorities again took a decision to uphold that compulsory retirement with effect from 31/12/2004. That is the original date. They moved a writ petition before this honorable court saying that the termination of service cannot be from a retrospective date, should be from a prospective date. So, my lord, now we have altered it to be effective from 28/10/16. What remained was the interregnum period. What to do with the interregnum period? Since they have not rendered any service, we are not in a position to give them the salary for that period. But since we have now postponed the date of the compulsory retirement, we are agreeable to give them the notional continuity in service, notional increments, notional whatever they would have got had they retired on 28/10/16, whatever benefits would have accrued to them, that we are calculating and we are ready to do. And that my senior
Petition
friend
already
has
expired. And therefore, I predicted that the direction we giving, that all benefit, retirement benefit should be given to these legal heirs.
And in fact, my lord, in the next item also, if on the basis of this resolution, the writ petition is closed, giving them an opportunity to come back if they have a grievance on the same.
Resolution 10.
Resolution 10 relates to my.
Resolution
Yes,
10,
yes,
it's,
yes.
so
Yeah.
far my client is concerned.
So you want to take some time?
I think better because this sort of
Okay,
client.
let him take some.
Otherwise, WBC, second item number 2 can be closed.
Item number 2. WBC 752. Heard Mr.
P.P. Burrow.
P.D. Baral and the council. Mr. R. Majumdar, London Standing Council, Dibrugarh University, submits that the Executive Council, Dibrugarh University, in its 355th meeting held on 26/9/2023, had resolved that the date of effect of the penalty of compulsory retirement imposed upon the petitioner by order dated 28/10/2016 stands modified as 28/10/2016 instead of 31/12/2004. Accordingly, the petitioner would be eligible for enhanced pensioner benefits
Or
to be
28/10/2016.
calculated on national continuity in service till 28/10/2016. Stop. It was further resolved that accepting the pensioner benefits to be calculated on national continuity in service
It is only expired.
till 28/10/2016. Petitioner would not be eligible for back wages, salary, any form of allowance and any other financial claims whatsoever. Stop. Para. Mr. B.B. Baral and counsel for the petitioner. At this stage submits that the petitioner had expired on.
Expired already. We have already substituted his name already.
Died on 14/11.
14/11/2021.
14/11/2021. And therefore, if any benefits are to be granted to the petitioner, the same will be done to the legal heirs. Recording the same, this writ petition is disposed of. Directing the respondents in the Dibrugarh University to pay all benefits which are to pay all the benefits which are to say recording the same, recording the same writ petition is disposed of, directing that all benefits eligible to the petition, to the late petition, shall be paid to the legal heirs of the petitioner at the earliest. That much should do. Stop. In the next petition, just write Mr. S.S. Datta, S. Datta, Learned Senior Counsel, assisted by Mr. S. Datta, Learned Counsel for the petition. Stop. Basically the same thing, isn't it?
Same. We have given him the same.
You just record what I've stated on top.
The dates would
Resolution 10. Okay. Mr. Para, Mr. S. Datta, Learned Senior Counsel, space for some time to enable him to receive his questions.
Your
Yes, sir, Lord.
Lordship may fix it on 21/11 maybe.
21/11.
Obligation.
Could it be 22nd, my lord? I'm not clear on it.
Yes.
Whatever it is, 22nd.
I'm so obliged.
Obligation.
I'm keeping the copy because
Made to the lordship. In this case, the petitioner with the lordship is praying for a review when order
who
passed by the
appears on the
lordship.
other side?
Secondary Education Department, my lord.
Secretary Majumdar, you're there?
My lord,
Who is the order for review?
lordship, at page 84, my lord. My lord, the relevant portion starts from page 85, my lord.
Yes.
My lord, paragraph 3, my lord. This must be brought on
1
record.
minute, 1 minute. Yes.
My lord, paragraph 3, it was held that, my lord, the petitioner before lordships did not complete 10 years of teaching experience. In fact, my lord, he was appointed in the year 2001. And in 2010, my lord, his service was adjusted against regular vacant post. Initially, he was appointed against under the OBB scheme. Subsequently, my lord, he was adjusted against regular vacant post in 2010. Since then, my lord, he is regularly working as teacher, a graduate teacher, in fact, my lord, in ME school. He, my lord, prior to his appointment, my lord, he was a master's degree holder in mathematics. In 2009, he passed MSc in mathematics, my lord. Well, in the case of Minaram Kumar, this honorable court has already held that the graduate teachers working in ME school and in high school, they cannot be treated differently.
Has the director passed any orders?
He has not passed any order. Malad. In fact, Malad, after this order was passed, my lord, lordship passed this order. On 28/7/2022 and on 26/7/2022, the private respondent hearing was placed under suspension. That aspect was not placed before lordship, that he was placed under suspension. And therefore, my lord, this honorable court directed the authority, my lord, to allow the private respondent to continue as in charge headmaster of the school till an order is passed by the director.
Who are the respondents in this review? Is the private respondent also?
Private respondent is also there, my lord. But only difficulty has arisen, my lord, in this case. The regular selection for the post of headmaster in high school is, my lord, is going on. In fact, my lord, the seniority lists are called by the director from the respective districts for the purpose of selection. If this order remains, my lord, then, my lord, my case will not be considered.
Why?
Because lordship has already held that, my lord, I did not have the requisite qualification, as I did not complete the 10 years of service teaching experience. That is 29/8. Well, at this stage, lordship may stay the portion of the particular portion, my lord. Otherwise, well, that lordship may observe that.
You were represented at a stage. You were represented by a council.
Yes, madam. I admit that, madam. I was represented by a council, madam, that was not informed by the council before a lawsuit. That is why this, my lord, inadvertent error kept in, my lord.
And respondent number 5 was also represented by a
Yes,
council.
yes, my lord. He also not placed before a lawsuit, that he was placed under suspension. On 26 suspension order lawsuit filed.
Is it correct, Majumdar, that respondent 5 is under suspension?
Subsequently, he
That
was
instruction
reinstated.
particularly I'll have to take, but otherwise, my lord, my humble submission, this review petition is not maintainable. This honorable court has held that if a review petition is filed after 30 days of passing of the orders in the writ petition, then there has to be some explanation of the delay. In the absence of any explanation, the review petition has to be dismissed.
When was when was it filed?
2020.
But,
It is a 2023.
it was filed on, my lord, 29/8/2023.
The orders, my lord, they
After
were
1 year.
passed on 20th/7/2022. So beyond 30 days, there has to be an explanation is my lord,
What is the limitation period?
my lord, there is no limitation
in the
on
review
review,
petition, there is
but
no review.
it has been held by the division bench and also it has been followed now that if it is filed after more than 30 days, there has to be some explanation for the delay at all. I've just gone through the review petition, but there is no explanation at all. So it has been held to be that the review petition will not be maintainable in that case. That is the first observation that I would like. I am happy. Second is, my lord, the judgments which have been referred to, these were matters which were required to be argued at the petition stage. These cannot be, my lord, matters of review. If there's something which it's not satisfied with, the petition is not satisfied with, the option is an appeal. The review apparently has been filed because once the review is dismissed, the limitation has to be covered. It is more than a year. The decision had come from this honorable court. There was no appeal. There was no contempt. Nothing. Now it is only to make up that bridge that gap. A review has been done. That case, this review would perhaps not be maintainable at all.
Of this honorable court, my lord, on finding of fact, which is, my lord, which was not placed before lawsuit properly by the respective council, my lord. So, my lord, in this case, my lord, regarding finding of facts, my lord, only the review is the only alternative, my lord. Appeal does not lie in this case, my lord. Because I have
Writ
to.
appeal is a continuation of the writ petition that is settled. Writ appeal is continuation of the writ petition. Grounds not taken in the writ petition can be taken in a writ appeal because it is a continuation. This argument perhaps will not stand.
Findings of fact, that findings is, it cannot be altered, my lord, even if without referring a review, my lord. The findings by your lordship.
Have you given any explanation why you are filing it after 1 year?
None that I could. And in fact, there is another shortcoming here. The review petition has been moved by a counsel who's other than the counsel who represented the writ petitioner in the writ petition. My lord. Supreme Court, Honorable Supreme Court has held clearly a review petition has to be filed, or at least it has to be supported by an affidavit of the advocate necessary, or he has to assist if there's a review petition. Because what happened that day inside the court is what the council knew and what the court knew. A new set of councils would not be entitled to file in the review petition. No. All in all, this review petition cannot stand.
Separate counsel cannot be well,
that is
barred
the law.
from appearing in the review petition.
That is the law.
Whatever it is there any explanation?
My lord, in paragraph 16. My lord, what happened, my lord?
I can give you liberty to file an additional affidavit explaining the delay.
My lord.
Explaining the delay in approaching this court.
My lord, as your lordships directed the, my lord, director to pass an order, the petitioner was waiting for the order to be passed by the director.
That I don't know.
Well,
That
yes,
is a
my lord.
verbal, that is a verbal
And
submission.
in the meantime, my lord, he was also allowed to continue as, my lord, as the academic in charge, the petitioner, review petitioner, and the inspector of schools was holding the charge of headmaster. Of late, my lord, the respondent number 5, he was appointed as the in charge headmaster of the school, though he did not have the B.Ed degree. And my lord, while the order was challenged before this honorable court, challenging the order of appointment of the private respondent number 5 as in charge headmaster of the school, this honorable court was of the view that my lord, until and unless that order is reviewed,
But respondent 5 will also have to be notified, isn't
yes,
it?
yes, definitely, my lord.
Will have to be notified.
Yes, my lord.
Any notice was issued to him?
No, my lord, this
It's
is the
come for
first
the first
date, my lord.
No, first time is coming up.
Yeah. Last day it came though, my lord, matter of due to paucity of time, it could not be taken up, my lord. Last week, my lord, when the Honorable Chief Justice, my lord, was elevated on that day, my lord. Now she was in a hurry, my lord.
Then we'll issue notice to the respondent 5.
My possibly issue notice, my lord.
In the meantime, I'll allow you to file an additional affidavit.
My lord.
Explaining the deal. But I cycle on the council for the petition. Review. Issue notice. HR Majumdar and Standing Council. School Education Department. Appears on behalf of the respondents.
Department of School Education.
1 to 4.
1 to 4, my lord.
Stop petitioner to take steps for service of notice on respond number 5 by registered post CD within 1 week.
Along with Dusty, my lord.
Stop. Additionally, petitioner is also permitted to cause service of notice on respond number 5 by Dusty service through the registrar of this court within a period of 1 week.
1
week from today. Thereafter, petitioner shall file an affidavit to the effect. Stop. Is the matter after 3 weeks. In the meantime, petitioner is also permitted to file an additional affidavit explaining the delay in approaching this court by way of petition 6.
Obliged, my lord.
I'm obliged.